for commencement of judgment at number 27 and day 1 of 2015.
Appeal dismiss.
At number 28 and day 23 of 2022.
Appeal dismiss.
May it please your lordship, I beg to mention item number 26. I have taken the consent of the other side. In this case, learned senior counsel Mr. Bisidas sir is not well. So let the matter may come after due vacation.
Date may be fixed. Okay, suggest the date. My lord, can it be on
February.
no, can it be on, my lord, on 29th January? 29th, yes. Okay, all right. This is S. Roy, learned counsel for the appellant. Okay, with consent from the other side. Price
6
for
January.
the matter
6 February. Thursday.
20. Okay. Keep your place.
May it please your lordship.
Huh?
Madam, with extreme apology, my lord. I'm praying for listing of a civil revision matter at 2 o'clock. I'm not praying for injunction. I'm praying for ex parte ad interim injunction. The matter has been fixed in February by the trial court. In the meantime, everything will be in flux, my lord. That is my only anxiety.
When the next date is fixed?
25th of February.
So why?
Because without any authority whatsoever, they're barging in to make constructions. We say, let us stop. Let there be a pause button. Without anything, it has been
No,
fixed.
not today, tomorrow.
My lord, this is going on. That's
No, tomorrow.
tomorrow, my lord. Tomorrow.
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 Right, please, Your Lordship.
Yes.
My lord, this is also a civil revision petition IO, my lord. Civil revision IO. So, my lord, may I pray for listing it tomorrow for motion, my lord.
When?
The urgency is there, my lord, because on 4th, the matter is fixed for argument
When?
without on
When do you
4th of
want?
January, on reopening, 4th of January.
When do you want?
Tomorrow, my lord, tomorrow.
Tomorrow. So,
Oblige. Oblige. Oblige.
My lord, I beg to mention one matter related to injunction. My lord, lordship has part heard the matter and fixed the matter on last 28, my lord, 28 November. But lordship was not available in this month.
altered matter?
Yes, my lord. Day after tomorrow, my lord.
Altered.
Part heard, yes, my lord. It's part
Okay, tomorrow.
tomorrow. My lord, day after tomorrow, my lord. It will be continued.
Okay.
May I please, lordship? I beg to mention item number 30. I am respondent number 4. I have filed affidavit in opposition and I have for vacating order with
Item number 30.
30. Kindly call for record to take this matter. 30. 1.
When you have filed the affidavit? You are appearing on behalf of?
D.
Item number 30.
Item number 13. 1. 3.
1 3.
I am respondent number 4.
You inform the other side?
Yes.
Your good name, please?
S. Rajbungs.
S.
Rajbungs.
Miss S. Rajbangse, learned counsel appearing on behalf of Mr.
Miss D. Deka.
Miss T. Decker, learned counsel for the respondent number 2. Rest shall list the matter on. When?
Next.
After?
After 1 week.
1 week. Okay. After vacation.
I please your lordship. Lordship, I beg to mention item number 17.
Yes.
Lordship, kindly fix after vacation,
After vacation.
9 or 8 January.
Your good name?
R. Begum.
Miss R. Begum, learned counsel appearing on behalf of Mr.
On behalf of Y.S. Vannan.
Item number 7.
17. 17.
On behalf of Mr. Y.S. Manan, learned counsel for the accused, recessal is the matter after vacation.
Kindly fix it at 8 or 9 Jan. 8 Jan.
May I please? Lordship, I beg to mention item number 23. I am for the appellant Lordship, Planet Senior Counsel, AC Sharma, he is out of station Lordship.
Item number 23.
23 Lordship.
Your name?
DJ Boro Lordship.
Pardon?
DJ Boro.
The pair being made by Mr. So learned counsel.
On behalf of
Appearing on
AC
behalf of Mr. A.C. Sharma, learned senior counsel. Recessal is the matter when?
23rd
After
January.
vacation?
Bihu Lordship. 23rd January.
23rd January. Okay.
Proposal list item. Proposal list item, item 4.
May it please the lordship.
Yes.
May it please the lordship, this is an appeal under section 30 of the Workmen's Compensation Act, my lord. The substantial question of law framed in this case is that whether the learned commission under the Employees Compensation Act 1923 can pass an award in respect of a non-civil injury without there being any assessment of loss of earning capacity by the medical practitioner as required under section 41C2 of the Act, and whether the learned commission under the Employees Compensation Act 1920 has the jurisdiction to assess the loss of earning capacity from his own milord. In this case, my lord, the claimant was the driver of a vehicle, and the accident occurred on 23/8/2001, my lord. And as per doctor's evidence, the claimant sustained injuries in left hand and right eyeball, fracture of nasal bone or official involving upper and lower lip, cheek, forehead, and nose.
You are reading?
I'm just. May I read the judgment, please?
No. From where you are reading?
From the judgment.
Memo of appeal or
No.
judgment?
Judgment, my lord.
Judgment is at page number?
Page number 5, my lord.
Yes.
And the case arose in a claim petition under Workmen's Compensation Act 1923 by the claimant petitioner for an award on account of personal injuries caused to Sri Laldhari Chaudhary in course of his employment. The case in brief is that Sri Laldhari Chaudhary was employed as driver under the opposite party number 1, the owner of the vehicle number so on 23/8/2001, when the petitioner proceeding from Golokganj to Dhubri met with an accident at 4 p.m. at Domoddaha National Highway 31 under Golokganj PS and sustained multiple grievous injuries in his person, which are permanent. It happened in the course of and under the employment of OP number 1, resulting permanent disability. It happened when another truck coming from Dhubri knocked forcibly and caused the accident. He became senseless and got admitted immediately at Dhubri Civil Hospital and regained his sense after 1 week and came to know after getting sense 2 persons already died and others got injuries and the Maruti car completely damaged. He stated that he was brought to the hospital by some other persons. Thereafter, he was shifted to Guwahati Medical College Hospital and stayed there for 18 days. One of his eyes got damaged and replaced by another eyeball, and also he deposed that his left eye also got injury and eyesight is going to be deteriorated day by day. Further, the petitioner stated that after releasing from the Guwahati Medical College Hospital, he took treatment at Nishiganj for more than 1 month and still his treatment is going on at Dhubri Civil Hospital and not cured yet. The petitioner further stated that a case has been registered under Golokganj Police Station by number and notice under section 10 was served to the OP number 1 who paid no heed to pay any money and advised the petitioner to seek compensation from the OP number 2 National Insurance Company Limited who insured the vehicle under policy number and was valid up to so. As the petitioner became unemployment due to the accident, demanded 4 lakh with 50% penalty and interest at the rate of 12% per annum on the amount of compensation, and the petitioner further stated that he has submitted all the relevant documents to substantiate the claim. The OP number 1, the owner of the vehicle, stated that the said vehicle originally belongs to one Srimati Meena Kharbanda and purchased the same by the OP number 1 and transferred the vehicle in the name of the OP number 1 duly and changed the vehicle number so and so accordingly. The necessary changes were made in the registration certificate, etc. Further, the OP number 1 admitted that the vehicle was duly issued by its certificate number so and so and valid from so and admitted about the employment of the petitioner. The OP number 2, the National Insurance Company Limited, in their written statement denied responsibility suggestively and mainly on the ground that the claim is not at all maintainable. Claim is barred under Section 10 of the Workmen's Compensation Act, and there is no cause of action. Claimant is not a workman and denied about the accident, injuries, salaries, age, etc., and the claimant is put for the strict proof thereof. Heard argument from the learned advocate for and against, and on pleading the following issues have been framed. Is there any cause of action for the claimant petitioner? Whether the claim petition is maintainable in its present form, whether the OP is liable to pay compensation as claimed by the claimant petitioner. If yes, what relief is the claimant petitioner entitled to? The claimant petitioner is the driver of the said vehicle and has been examined by the learned advocate of the case. Adduced documentary evidence pertaining to his claims such as Exhibit 1 FIR, Exhibit 2 to 4 seizure list, Exhibit 5 notice under Section 10, Exhibit 6 postal receipt, Exhibit 7 driving license, Exhibit 8 medical certificate from Dhubri Civil Hospital, Exhibit 9 medical certificate from Guwahati Medical College Hospital, Exhibit 10 discharge certificate from Guwahati Medical College and Hospital with details injury report, Exhibit 11 pathological report, Exhibit 12 radiological report, Exhibit 13 up-to-date medical certificate from Dhubri Civil Hospital, Exhibit 14, 15 prescriptions from Shankardev Nethralaya, Exhibit 16 patient's identity card of Shankardev Nethralaya, Exhibit 17 to 21 entry pass of Shankardev Nethralaya, Exhibit 22 ambulance fare receipt from Lions Club Dhubri, Exhibit 23 to 27 X-ray report, Exhibit 28 to 40 cash mob, Exhibit 41 statement of expenditure by the claimant, copies of insurance policy, and one extra plate as material exhibit to substantiate the claim. Issue number 1 and 2. This is the claim case in respect to injuries sustained by the claimant petitioner. The petitioner had been examined and cross-examined by the learned advocate of the case, adduced documentary evidence mentioned above. I have gone through the different documents pertaining to the accident, such as police report, doctor reports, and other related documents which establish the fact. So there is a cause of action for filing the claim. Subsequently, the OP number 2, National Insurance Company Limited, submitted a prior petition dated for amendment inserting after para number 6 of the written statement. And at the time of alleged accident, the claimant was not a workman under Meena Kharbanda, the policy holder, and it had no contractual liability with the OP number 1 at the time of alleged accident. Hence, the insurance company is not responsible towards any liabilities as claimed for. On the other hand, the claimant side also filed written objection dated so and so against the amendment petition of the OP number 2 Insurance Company Limited. The court, on perusal of the petitions filed by the two parties, had given order dated 3/12/2005 in favor of the claimant petitioner. The copy of the order had been served duly to the concerned parties. Hence, the plea of OP number 2 has been rejected. The claimant petitioner brought one witness who was the conductor of a super bus, witnessed the scene on the very day, and stated clearly that the accident occurred on 25/8/2001 at about 3 to 4 p.m. at Dumaradaha, and the vehicle Maruti car, which was driven by Sri Laldhari Chaudhuri, got head-on collision with another truck coming from opposite direction, and as a result, Laldhari Chaudhuri, the petitioner, sustained severe injuries and became senseless. Two passengers already died, and he himself brought petitioners to the Dhubri Civil Hospital and informed about the accident to his house, and as he knew him as local person. The doctor who treated the patient at Dhubri Civil Hospital attended the court and deposed that the patient got severe injuries, mainly in left hand, where both bone of left forearm injured previously, and it was compound fracture, and also got injuries and right eyeball fracture of nasal bone with gross depression of nasal breach, gross of laceration of the orificial region involving both upper and lower lip, thick forehead and nose and head, which are grievous one. And further, the doctor stated that the above injuries are permanent in nature and causing difficulties to do his own job and assist 60% disability. The court is also observing the claimant physically he could not do his permanent job due to the injuries sustained by him in the accident and required better treatment for his livelihood in the near future. In the present condition, the claimant is completely unfit to do any job in these precarious conditions, and he becomes incapacitated for all works which was capable of doing at the time of accident. Further, the petitioner stated that he had already spent a good amount of his treatment and still the treatment is going on, and he required advanced and better treatment for eye and face. Therefore, by observing his physical injuries sustained in the accident, the court is decided to hold the percentage of disability at 80% as the accident reduces his earning capacity to that extent, and the same has been assessed keeping in mind of his physical injuries genuinity backed by basis of the related factors and justice. The learned advocate of the OP number to National Insurance Company Limited stated that the petitioner failed to serve the notice under Section 10 of the WC Act to the OP number 2. On perusal, it is seen that the petitioner served notice under Section 10 of the WC Act to the OPs with registered post. In this regard, I would like to place court's rulings. If an employer has knowledge of accident suffered by the workman, the notice of accident is presumed. And another is it held that insurance company cannot escape liability because notice was not issued to the insurance company. Notice to the owner of the vehicle is good enough. Hence, the plea of OP number 2 is not acceptable. I have gone through the FIR police report of the concerned PS and seizure list where specified fully about the date, place, time of accident, police case, vehicle description, etc., which cannot be denied. So it is fully established that Silaldari Chaudhary was the driver on the day of accident and sustained severe injuries and became unemployment, which cannot be denied. Hence, the petition is maintainable in the present form and issues 1 and 2 are answered in favor of the claimant petition. This is the claim petition in respect of injuries caused to Silaldari Chaudhary of the said vehicle. From the foregoing paragraphs, it is fully established that the claimant sustained serious injuries in the accident on Wednesday at Dumra National Highway under Golokganj Police Station while he was on duty. An accident which occurs on account of risk, which is incident of employment, that the claim for compensation can succeed provided the workman has not exposed himself to an added peril by his own imprudent act. So next page, page 10. Therefore, I am on the opinion that Silaldari Chaudhary driver entitled to compensation, but as the vehicle was under insurance coverage at the relevant period, the OP number to National Insurance Company Limited, Dhubri branch is liable to pay compensation for and on behalf of the OP number 1, the owner of the vehicle. The issue is answered accordingly. This is a case of personal injuries caused to Silaldari Chaudhary, driver of the said vehicle, and the petitioner is entitled to compensation on the following head. Although no amputation was done and the injuries are not specified in schedule, and the petitioner submitted various relevant documents from the different hospitals and that he took treatment fully substantiated his injuries, and on the basis of physical injuries and the loss of earning capacity to this effect, the court has decided to hold 80% disability. The reasons and basis mentioned in the foregoing paragraphs and as empowered under the provision of the Act. According to the petitioner, his monthly salary was 2,000 and daily allowance of rupees 70 per day, totaling 4,100 per month, and his age was 35 years at the relevant period, and that had been mentioned in the medical certificate issued by doctor. Now, therefore, if his age to be taken as 35 years and monthly wages to be taken as 4,000 as per explanation 2 of section 4 of the Act as amended, the petition is entitled to compensation as per clause C of subsection 1 of section 4 of the Workmen's Compensation Act 1910 as follows: 80% is 2,004 into a total 3,78,355 rupees, 3,78,355 only, and the interest at the rate of 9% per annum as per verdict of the Honorable Supreme Court passed on students on the writ petition number students, the owner of the vehicle shall have to pay. In view of the above decision, the claimant petitioner Silaldari Chaudhary driver is awarded compensation of rupees so only. The opposite party number 2 National Insurance Company Dhubri branch is directed to deposit the awarded money to the court within 30 days from the date of the award to disburse the same to the claimant petitioner, failing which the undersigned will be compelled to initiate legal proceeding as per provision of section 31 of the Workmen's Compensation Act 1923 to recover the said amount as area of land revenue so. Further, the opposite party number, the owner of the vehicle, is directed to deposit interest amounting to rupees only to the court within 30 days from the date of award. If the OP number on page to the legal proceeding shall be initiated to recover the said amount as per section 1 of the Workmen's Compensation Act, so and so as area of land given under the Revenue Recovery Act 1890. You know, in this case, the substantial question I explained is we are challenging the jurisdiction of the learned commissioner Miller. Here, the doctor assessed the disability at 60%. Doctor did not assess the loss of earning capacity. The loss of earning capacity was assessed by the learned commissioner. And as per WC Act, he has no jurisdiction to assess the loss of earning capacity. The doctor has to assess the loss of earning capacity. As per WC, there are two types of it. One is schedule injury and non-schedule injury. In schedule injuries, injuries are provided in the schedule of the act, and against their schedule loss of earning.
What are the schedule injuries and what are not the schedule injuries? Cover it as topic.
Page number 44, Milord, Employees Compensation Act,
Page number 44.
44.
Yes.
Here the schedule injuries are mentioned, and against that, percentage of loss and earning capacity was mentioned, Milord.
Part 1 or part 2?
Part 1, part 2, both. Part 1 is permanent total disablement, and part 2 is permanent partial disablement. But the injury sustained by the claimant in the instant case is non-schedule injury. And the commissioner himself also came to the finding that injuries are non-schedule injury.
Let us see the section 4.1 C Roman 2.
4.1C, amount of compensation. C is where permanent partial disablement result from the injury. In case of an injury specified in Part 2 of Schedule 1, such percentage of the compensation which would have been payable in the case of permanent total disablement as is specified therein as being the percentage of the loss of earning capacity caused by that injury. And in case of say 4C2, in the case of an injury not specified in Schedule 1, such percentage of the compensation payable in the case of permanent total disablement as is proportional to the loss of earning capacities as assessed by the qualified medical practitioner permanently caused by the injury. Here it is mentioned the loss of earning capacity has to be assessed by a medical practitioner.
So here the doctor was not examined.
Doctor was examined, but doctor said that this only evidence is given disabilities at 60%. But the learned commissioner himself assessed the loss of earning capacity at 80%.
Yes. What is the part?
Doctor has to assess the loss of earning capacity. Doctor is silent regarding the loss of earning capacity. The commissioner himself assessed the loss of earning capacity at 80%, Milord. And he cannot do so as per Act, Milord. This is an error.
No. Is there any bar in the act itself that in absence of the assessment made by the doctor, the court cannot assess the
Yes, Milord.
compensation?
Yes, Milord. And in this regard, our Honorable High Court judgment, several judgments are there, Milord. I'm placing first judgment is
Okay. Okay. Okay.
7, New India Assurance Company versus Sanjit Kumar. This is, your lordship may come to para number 2 of your judgment. I have heard so and so learned counsel for appellant, so and so learned counsel for response. It is urged by Mr. Borkoti learned counsel for appellant as follows.
So that's all right. Where is the finding of the court?
Para number 1 and 2, 2, 1 and 2. That the mode of assessment of loss of earning capacity and the person
No, no,
competent.
that is the argument advanced by the counsel.
Then 2, my lord, in view of the specific requirement of the provision of section 4(1)(c)(2)
No, that is also argument.
the work para 4, my lord, the Workmen's Compensation Act provides the mode and method to determine the compensation. The court cannot adopt some mode or method which is not provided in the act. In the portion of the award quoted above, the court determined the percentage of loss of earning capacity at 50%. That power is not available with the commissioner. So this award shall stand paused, and the matter now shall go back to commissioner to assess the compensation afresh. And in order to do that, he may even ask the doctor to appear before him and give his opinion with regard to percentage of loss of earning capacity, Miller. Then your lordship may to 2008 supply GLP 329 United India Insurance Company versus Monoranjan Dash. Para number 10, Miller. A plain reading of the above provision of the Act makes it manifest that where permanent partial disability results from an injury not specified in Schedule 1, the compensation payable would be the percentage of amount awardable in the case of permanent total disablement as would be proportionate to the loss of earning capacity to be assessed by qualified medical practitioner. Thus, the assessment of loss of earning capacity precipitated by the injury caused is a sine qua non for a valid quantification of the amount payable. If certain injury is not one specified in Schedule 1 of the Act, the legislative prescription is clear and unambiguous. Had the lawmakers intended to empower the Commissioner, Workmen's Compensation to make any independent estimate of the loss of earning capacity on the basis of other materials on record, even in absence of such assessment by a qualified medical practitioner, such a specific requirement would not have been incorporated in the above provision of the Act. One of the basic tenets of interpretation of statutes being that the legislature does not unnecessarily employ any word or expression. I do not feel persuaded to hold that the words as asserted by the qualified which are to be considered as an useless appendix to the provision involved. In other words, in my considered an assessment of the loss of earning capacity in case of injuries not specified is a condition precedent for illicit assessment of compensation comprehended in section 4(1)(c)(2) of the Act. Para 12. In the case in hand, the evidence of the doctor is deficient in the above in respect to in as much as the same does not indicate any loss of earning capacity following the injuries sustained by the opposite party claimant. The amount awarded on the above consideration alone cannot be sustained. The award is thus set aside. Then your lordship may come to 2017 Supreme for New India Assurance Company versus Gopal Shield. Para 7 onwards, my lord.
Yes.
Para 7, the learned counsel for the appellant has submitted that in the presence the doctor did not assess the loss of earning capacity, and therefore there being no assessment of loss of earning capacity by a doctor, it was not open to the learned commissioner to assess the loss of earning capacity in the absence of any valid certificate to that effect. It is further submitted that the loss of earning capacity must be assessed not only on the basis of income of the injured respondent number 1 in his capacity as a driver, but such loss must be in relation to any other employment which the respondent number 1 is able to carry out for his livelihood. It is further submitted that the appellant could not have been foreseen the liability to pay penalty from the date of action, and such award can only become due from the date of default. So and so, and then your lordship may come to another judgment. 2016 Supreme Mohammed Noor Jamal, paragraph 6, my lord. As pointed out above section 4(1)(c).
Madam, you see how this judgment will help you because in the present case, the doctor was examined.
Doctor was examined,
Then
but
on the basis of the evidence of the doctor, the commissioner has quantified the.
commissioner cannot do so, my lord. The commissioner himself may can asked the doctor what is the loss of earning capacity. A loss of earning capacity was not assessed by the doctor, my lord. The
But
commissioner,
in this case, the case you have referred to, here the doctor was not examined.
but in
Yes, the next judgment.
next judgment is Oriental Insurance Company Limited versus Mohammed Noor Jamal. Paragraph 6, my lord. As pointed out above section 41C2 of the Act, it is clear enough to hold that loss of earning capacity.
Paragraph number.
Paragraph 6.
India Assurance and Assurance Company Limited versus Gopal Sil.
No, Oriental Insurance Company Limited versus Mohammed Noor Jamal, my lord.
Yes.
As pointed out above, paragraph
In that case, the doctor was not examined.
as pointed out, the author is enough to hold that loss of earning capacity of a victim can be ascertained only on the basis of opinion of the qualified medical practitioner. In the case in the claimant did not examine and qualify on the learned WC Commission assumed the judicial.
Anyway, come to the next judgment then. Gopal Sil.
I relied upon court judgment, my lord.
Acha. Okay. No, in the case of Gopal Sil,
Doctor was examined in Gopal Shil. Paragraphs of the learned.
which paragraph you have relied upon here?
Paragraph 7, my lord. It was since the doctor was
No, that is the submission.
CW2, Dr. CW2. Paragraph number 9, my lord. In the injury report exhibit A, the Dr. CW2 did not certify the loss of earning capacity of the respondent number 1. This court in the case of New India Shares Company versus Sanjit Kumar and another reported instance has held that the power is to determine the percentage of loss of earning capacity is not available with the commissioner. The relevant passage thereof is already quoted, but the ratio laid down in the case of students was subsequently followed by this court. In view of the on finding that the present case is similar on facts and case of the Palkusha and other, this court is of the opinion that as regards first substantial question that the learned commission of workmen's compensation does not have the power to make its own assessments of the loss of earning capacity without there being a medical evidence to that effect as provided for section 41C2 of the Workmen's Compensation Act 1923. Hence, first substantial question of law is answered in the negative and in favor of the appellant by holding that the learned commission of workmen's does not have the power to assess the loss of earning capacity on its own.
Yes, Mr. Sharma.
Thank you. The ultimate need to tell the question, substantial question of law is a brave.
Yes. There ought to have been one substantial question of law.
I will come to that one. Number one,
Hmm.
whether the landed commissioner committed illegality in assessing the amount of compensation in the absence of any medical evidence.
No, my lord, a substantial question was framed subsequently.
Now, my lord,
Separate sheet was given, my lord, and order was made.
if answering this question, my lord, this question is it a case where there is no medical evidence exists? It does. Lordship have just seen that the medical officer has taken enough care while examining the patient at the time of accident. He examined him, noted down all the accident, then cumulative effect of that physical disability is 60%. Now, my lord, he has done his duty so far as 41C2 is concerned. My lord. He has taken care of all the effect of the injury on his body, physical incapacity in earning. Now, that matter goes back to the trial court and learned commissioner. Now, the commissioner, your lordship, has also seen that in view of those findings of the medical officer, he has reassessed the economic loss resulting from those injuries. Because my lord, when witness is examined, he is also discussed this part that when I examined, I found his physical position this way, his income capacity. So I reassessed this 80%. Now, my lord, both of them are to exercise their respective jurisdiction when this permanent total disability of 412. Now, I will place only one decision, my lord, the apex court, my lord, that will dispel all the doubt. One decision. And one decision I will cite, so far as the last question is, daily allowance. They challenge the daily allowance also. The daily allowance was 70 rupees daily allowance was, you will still fight last person that, 2000 salary plus 70 daily allowance is taken while to declare compensation.
No, on that point, there is no substantial question of
Yes,
law.
but I will, place only two decisions. One, both are respect, one in respect.
Yes, we produce it.
Yes, yes. I will only submit to two decisions. Just, I will not take any further time. The first case, Mr. Musabir Hussain, reported in 2007 to SSC,
Hmm.
case 349, and please cut the page, my lord. Next page, too. At 350, you will tell that the Lord is considering a number of appeals, my lord. Now I come to the 1, 2, 3. So 3 appeals they were considered, and I will give you appeal number 5623 of 2006. Permanent partial disability 65%, loss of earning capacity 80%. Then next disability 5624. Permanent partial disability 65%, functional disability 65%, loss of earning 65%. Third one, madam. Permanent partial disability 65%, financial disability 70%, loss of earning capacity 80%. So Lord, now, Lord, I will come to example. I'm reading the click. These cases, I'm reading the third paragraph. These cases, I will go to these cases.
Hmm.
These cases related to injuries which were not specified in Schedule 1, and as such, cases are covered by Section 4132. Explanation. In terms of explanation 2, a explanation, if the qualified medical practitioner has to assess loss of earning capacity, having due regard to percentage of loss of earning capacity in relation to different injuries in Schedule 1. Explanation 1 also provides that where there are more injuries than one, the aggregate has to be taken. Aggregate has to be taken. So that the amount which would be payable for permanent total disablement is not exceeded. Loss of earning capacity is therefore not a substitute for percentage of the physical disability. It is one of the factors to be taken into account in the cases and cases. The doctor also examined the claimant. Also noted about the functional disability, functional disablement. In other words, the doctor had taken note of the relevant factors relating to the loss of earning capacity without indicating any reason or basis. The High Court held that it was 100%. So whatever happened, these repeals when the assessment was made by the commissioner, the High Court enhanced it as 100%. So the Lordship said that without anything in data, there must be something which discuss the percentage. You cannot take 100 without a rhyme and reason, my lord. I will come to the exact para, my lord. We unleash this paper. In the body of the judgment, my lord, you have to consider the entire matter, my lord. It is important judgment. I will read para 7, my lord. That appears at page. My lord. Para 7. These cases related to injuries which were not specified in Schedule 1, and as such, they are covered by Section 4132 explanation. In terms in terms of section 2, if the relevant medical practitioner has to assess loss of earning capacity, then regard to loss of earning capacity in relation to the different injury individual. Exception will also provide that where there is more than one injury, the aggregate has to be taken and shall amount to be payable on it not to achieve. Para 8. This is on relying on para 8. Loss of earning capacity is therefore not a substitute for percentage of the physical capacity. Is one of the factors to be taken into account in the functional disablement. In other words, the doctor had taken note of relevant factors relating to loss of earning capacity without indicating anything. Earning capacity. Any reasonable basis, the High Court held that it was 100% loss of earning capacity. Since no basis was indicated in support of the conclusion, namely the order restoring to the High Commissioner in view of the fact that the fact that the order and restore that of the Commissioner in view of act in view of the fact situation. The provisions has been quoted above. They have not quoted the 41C2 in full, my lord, in the before the in the earlier para. And they have discussed this law also. So, well, my response submission is this is a very clear case. There is absolutely no doubt that any jurisdictional error has been committed either by the medical practitioner or by the honorable commissioner. There is no, in my respective submission, is ineffective. And so far as this allowance is concerned, my lord, I am relying on one judgment.
I'm not challenging the allowance, my lord. I'm not challenging the allowance. My lord.
Here, daily allowance, my lord. This judgment relates to daily allowance.
Mr. Sharma, our discussion has to confine only on the substantial question of law. Mr. Sharma, there is no substantial question of law on this point, and therefore it is not
Head
necessary.
note, my lord. I am reading head note. There are 3 to 8 head note matter. What relates to the education, what regulate determination of compensation loss of earning. This is as a 20 years getting steady of 2,500. Besides, daily allowance of page 50. This is was unmarried and age of mother was 40 years. Tribunal assessed compensation 5 lakh and 1,000 on the basis of his income and applying multiplicity of 16 on the basis of the High Court reduced the amount of compensation to 2,060,000, taking the amount monthly salary only apply multiplied of 30. High Court exceeded daily allowance. Daily. There was no evidence of record that apart from the monthly salary 2,500, he was getting 50 daily allowance. Held. The tribunal was right in assessing monthly income of deceased 4,000, applying the multiplication of 15. Compensation awarded under the head of loss of 4,000. Determination of the compensation multiplied. Now, what I told you, submit, my lord. There is, it only one, the claimant was examined. He has clearly stated in chief that he is receiving 2,000 like salary and 70 daily allowance. They have also examined. There is nothing, my lord, that they have brought anything. They have disturbed that, they have disputed that part, that portion. So, my respectful submission, my lord, that the question which referred to your notes is opinion, my lord. Either note may reframe it or your answer in any way, but it has to be inserted under section 100. You will take a first of it. So, well, neither the learned commissioner nor the medical practitioner has committed any error of law matter. They have properly applied the evidence that after considering all the aspects of the matter, competition is very proper, my lord. Thank you.
Okay. Ms. Esroy, learned counsel for the appellant, and Mr. Sharma for the respondent. Argument concluded, judgment declared.
But it is very
Much of this.
Okay.
Item upgraded. Item number 5. Item 5.
Witnesses already available today.
Day before yesterday, paying me for salary. Typically, or paying for adjournment.
But no one appears. What to do? Okay, take down. None appears for the appellant on call. How about Mr. See, Boisha, Gusami, learned counsel for the respondent present. List the matter on
January.
in the event of subsequent non-appearance, appropriate orders will follow.
30th January. 30th January. So upgraded item number 22. Parent matter.
Procedural. Particularly Python matter for timing, Mr. Deka, he's on legs. He'll be coming in 5 minutes.
5 minutes.
5 minutes.
Okay. 5
Let's-
Now motion item number 1.
May I please read? My lord, this is an application, my lord. I'll under
So
section.
at what stage the case is pending now?
Evidence test, my lord.
How many witnesses have been examined so
Only
far?
3 examined, my lord, so far, my lord. And the accused, my lord, 4 years, 4 months inside jail, my lord. Date of arrest, my lord, that is 12/08/2020, my lord. More than 4 years. My lord.
In whose court it is pending?
Yes, my lord.
In whose court the case is pending?
Case is pending, my lord, in the sessions of Amingau, my lord.
Let the scan copy of the record come.
Yes, sir.
Heard Mr. T. Hussain, learned counsel for the accused, and Madam
and Kakoti Lord.
learned counsel appearing on behalf of Mr. S. C. Kayal, learned standing counsel for the respondent. This application under section 483 of the BNSS is prepared by accused Tarun Kumar, who has been languishing in jail as in connection with NDPS case number 8 of 2021, arising out of NCB crime number 12 of 2020 under section 20B, Roman 2, capital C, stroke 29 of the NDPS Act, since 12/8/2020. Files the petition and the documents placed on record. The registrar shall call for the scanned copy of the record, along with up-to-date status report from the learned trial court, fixing the matter on when
January 1st,
last week. Robert fixed it.
10/1.
Number 2.
Lordship,
Lordship, I'm very sorry, Lordship. Item number 5, Lordship. Actually, I received a phone call, Lordship. I was here only, Lordship. Lordship has fixed the matter on 30th of January, Lordship. Kindly record the presence of the petitioner.
The letter of
Item
Mr.
5. Mr. DJ Das, your Lord.
P. Das, learned counsel for the appellant, appeared.
Much obliged.
Item 2.
My lord, this is under NDPS, my lord, evidence stage. Already 5 witnesses, my lord, examined, my lord. And that 5 witnesses, my lord, nobody, my lord.
How many witnesses were cited in the search sheet?
10, my lord.
10. Out of 10, 5 have been examined. Whether the IO is examined,
Are you examined?
whether the IO has implicated him. Mr. Goswami, have you?
Just I am going to the witness.
But,
Okay, let the status report come from the trial court.
Lord.
Where it is pending?
my lord, I mean, my lord.
Amingau.
Lord.
Heard Mr. M.
I am
Hussain,
14, my lord.
learned counsel for the accused, and Mr. M. P. Goswami, learned additional PP for the state respondent. This application under section 483 of the BSS 2023 is preferred by the accused. Namely, Ina Sali alias Minos, who has been languishing in jail as in connection with NDPS case number 27 of 2024 under section 20C, stroke 29 NDPS Act, arising out of Nagarbera PS case number 127 of 2023. Where is the petition and the documents present record? The license shall call for the scan copy of the report along with up-to-date status report taking the matter.
All right.
This is a lordship. This is a second bill application, my lord. And in this case, my lord, out of 18 witnesses, 10 witnesses has already been examined. And we have annexed all the depositions, my lord. And all the, my lord, Caesar witness and independent witness did not, my lord, implicate the present petitioner. So we are renewing our prayer, my lord. At this stage, my limited prayer before this honorable court to call for the records and examine the matter, my lord.
Heard Mr. Sodore, learned counsel for the accused, Mr. Goswami, learned additional for the instance. Its application under section 483 of BNSS 2023 is preferred for accused. Sohidul Islam Bepari, alias Pintu, who has been languishing in jail as in connection with a special case number 41 of 2024. Arising out of Gubri PS case number 345 of 2023 registered under section 22C of NTPS Act. Where is the petition and the documents record? The register shall call for the scan copy of the record along with the up-to-date status report fixing the matter.
Yes, keep your blessing.
All right.
Item 22, after
Yes, Mr. Tecker.
My lord. My lord, first I'll begin with delay again, my lord. I had already addressed the chronology of events, my lord. Just to recapitulate, my lord, very quickly.
Yes.
Just to recapitulate the sequence of events, my lord.
Have you filed any document in connection with this chronology of events?
No, I have not. I have not.
Yeah, you have only submitted.
Yeah, I had already submitted.
Yes, 1992.
Yes.
Objection file.
Yeah, my lord. First will was executed in 87, my lord.
87 or 88?
87, my lord. 10 to 1987.
Yes.
My lord, the alleged then my lord, alleged testatrix died in 1988, my lord. And 1988 itself, my lord, petitioner applies for mutation as the son on the strength of inheritance, my lord. 1989, my lord, he was granted mutation, my lord. 1992, we file an objection stating that he is not the only son. Therefore, mutation cannot stand in his name solely. That application was dismissed on the ground of limitation in 1993, which is why, my lord, we prefer an appeal before the Revenue Board. 1995, my lord, the Revenue Board sets aside the order of the DC and remands the matter back. Then 1996, my lord, DC sets aside the earlier order and 1999 mutation is granted in respect of all the legal heirs. Now, my lord, insofar as the probate is concerned, 1998 was the first time that he filed the probate application, my lord. So from 1988 to 1998, my lord, he was totally silent about the will and he was claiming mutation on the ground of him being a sole legal heir, which is actually not correct, my lord, admittedly. So from 88 to 98, my lord, there was absolutely no claim on the basis of this will. Now, my lord, I had perhaps referred to the evidence, my lord, but just to recollect, my lord, during the evidence, my lord, all the witnesses had said the same version, that it was the propounder or the respondent himself who had arranged the drafting of the will way back in 1988. My lord, if your lordship has the C file,
Yes.
C file, my lord, it should be page 3 where the evidence on affidavits are there, my lord.
Yes.
This is page 3. There's a para 11 to PW1.
Yes.
That somewhere in the first week of February, while I was, this is the version of the attesting witness. This is the version of the attesting witness.
Yes.
That somewhere in the first week of February 1987, while I was in the residence of Dr. Manohar Bauri, my mummy, Stuti Devi Bauri, expressed her desire that she wanted to transfer her land and bungalow situated at Dibrugarh in favor of her son, Dr. Manohar Bauri. When all were talking, as such, Dr. Manohar Bauri also appeared in her room, and I requested Dr. Bauri to prepare the will of the mummy. Thereafter, both of us went to the chamber of B.L. Agarwal, advocate at Modi Lohia Road, Tinsukia, and requested him to come along with us to Dr. Bauri's residence. That Mr. Agarwal, being a friend of Dr. Bauri, came along with us and talked with her mummy in respect of her will and received instructions. After a couple of days, that is on 10th of February 1987, my mummy executed the will at her residence in Parbotia in my presence. She put her signature in my presence and myself, and Shri B.L. Agarwal also put her signature. Now, similar is the version of the other attesting witnesses. Now, what I'm trying to point out is this, Lord. The respondent himself was instrumental in preparing this will. I'm not saying it's genuine, not genuine, that is another matter, of course. But he had, it was in his residence when the idea of preparing a will was for the first time floated. So he was always in the knowledge of this particular will. Yet he chooses to file for mutation on the basis of inheritance, and he doesn't even make a claim on the basis of the will 10 years post the death of his mother. My lord, on the last occasion, your lordship had queried that whether this delay itself would be a suspicious circumstances. I had said I'll try to find a few judgments on this, my lord, because there are two facets to this delay, my lord. One is limitation, because I had placed the judgment which said that right to apply may not accrue on the date of death, but the moment there is a dispute, the right to apply under Article 137 will begin to run. Now, 98, I raised the dispute that your name cannot be there as the legal heir. At that juncture, at least your right to apply had accrued. So, which is why you should have filed the probate within 3 years from the day when I raised the dispute that your name cannot be here as a sole legal heir of your ancestor. It is that at that precise moment, his right to apply that no, I am not as a legal heir, but perhaps on the basis of a will, I am entitled to the property to be solely held in my name. His right to apply had accrued. So, given this, the right to apply had accrued, therefore it is barred by limitation. That is one aspect of the delay, my lord.
Yes.
Secondly, my lord, even if the point of limitation for a moment is kept aside, my lord, this delay itself is a suspicious circumstance, my lord. In fact, there are judgments which have said that delay by itself will not be a suspicious circumstances. One may not come within promptly, but coupled with the other circumstances, it can well become a suspicious circumstances in itself. In this regard, I'll just rely on two judgments, my lord. One of the Supreme Court and the other of the Madras High Court. Multiple. They're reported in 1977, 1 SCC 369. My lord, has the Supreme Court judgment, Jaswant Kaur versus Amrit Kaur?
Yes.
Para 14 of this judgment, if the lordship picks up.
Yes.
Circumstances are too numerous to mention, which throw a cloud of suspicion on the making of the will by Gobinder Singh. The will is alleged to have been made on November 26, 1945, but it did not see the light of day till August 20, 1957. Being an ambulatory document, it may be granted that there may be no occasion for anyone to know of its existence until the death of the testator on December 1955. But it should be ununderstandable, my lord. I've checked up the book, but it is ununderstandable that a document by which property worth lakhs of rupees was disposed of should have remained a closely guarded secret from the whole world of intimate friends and relatives, nay, from the sole legatee himself, for over 2.5 years after the testator's death. The testator had left behind him a large property and along with it a large amount of litigation, which makes it impossible to believe that upon his death in December 1954, no one bothered to go through his papers, which would reflect the state and extent of his property. The explanation of the defendant that he hit upon the will by chance while going through some of the papers of his grandfather is therefore patently lame and unacceptable. So the fact that it did not see the day of light for 2.5 years after the death of the testator was itself said to be suspicious circumstance. Now, my lord will mark here in this particular case, an explanation was put forth that we did not know about the will. And we suddenly encountered it some years later among his belongings, my lord. That is not even the case here, my lord. In our case, my lord, as per his own version, he knows of it because he arranged the entire calling of the lawyer. It was floated in the idea was floated in his house, etc. And secondly, my lord, the probate application here doesn't even make a mention that why there was a delay of 10 days. Now, if they would have come forward, with an explanation that the court could have tested whether it's a plausible explanation or not. But in the case at hand, firstly, he knew about the will. Secondly, 10 years later, he comes up after the death of the testator to say that I have a will in my favor. And thirdly, he doesn't even care to explain why he did not do it when there were numerous litigations pending before the revenue authorities as to whether his name should be mutated at all. So this delay of 10 years, even if the question of limitation for a moment is not taken note of, this delay, if not anything else, would give rise to a suspicious circumstance. The next judgment, the Madras High Court, my lord, it's reported in 2011 SCC Online, Madras 830. My lord, para 31 onwards, my lord. Delay in filing probate. Exhibit P1 will was allegedly executed on 24/5/95 and Krishnamurthy died on 28/2/97, but the OP 583 of 2001 was filed on 1/3/2001. In OP 583 of 2001, plaintiff made an attempt to explain the delay. In para 10, it has been stated as under, though the will was executed on 24/5/1995, there was no necessity for the petitioner to file probate proceedings. And in view of the necessity now, this petition is filed. So the delay in filing probate proceeding, and it has to be condoned. Per contrary, in his oral evidence cross-examination, PW1 has stated that he came to know about the execution of the will by his father only in 2001, and thereafter the probate proceedings was initiated. Placing reliance upon Ammu Balachandran versus UT Joseph, AR 1996-442, learned counsel for the plaintiff contended that delay cannot be treated as a suspicious circumstance for denying probate. It was further submitted that it is well settled that there is no limitation for the probate of the will, and while so, the learned judge erred in attributing mala fide on the ground that the probate was filed in the year 2001. From the time of execution of Exhibit P1 will and from the death of N. Krishnamurti, Exhibit P1 will did not see the light of day. It is quite ununderstandable why the bequeathed valuable property to the plaintiff should have remained secret. Contending that suspicious circumstances of delay in filing probate has not been dispelled, the learned counsel for the respondent 1 and 2 placed reliance on Srimati Jaswant Kaur and Amrit Kaur. In the said case, existence of the will was not made known, observed observing that it is why the will sure, as pointed out by the learned judge, 50% of the property belonging to N.S. Naidu, grandfather of the plaintiff, was already bequeathed. Plaintiff's father probated the will dated so-and-so in OP 2000 on 1986. Therefore, it is not as if the probate proceeding was unknown to the plaintiff. No convincing reason is forthcoming for the delay in filing the probate. Even though delay itself cannot be treated as suspicious circumstance, coupled with the other circumstances in this case, the delay in filing the probate is evidently a suspicious circumstance, and the learned judge rightly held that this suspicious circumstance has not been dispelled by the plaintiff. Now, my lord, so it says delay per se may not be suspicious. But if there are other circumstances, what are the other circumstances here? You are trying to acquire that property from 1988 onwards. There you have lied through your teeth claiming to be the only son of the erstwhile owner. You were yourself instrumental in preparing the will. So there is no question of you not even knowing. And lastly, you do not even come forward with an explanation as to why so much of delay in disclosing about this will. Now, my lord, since it says coupled with other circumstances, my lord, another suspicious circumstance when the executor himself takes a very prominent role in the execution of the will and he reserves the maximum benefit for himself in the will, by itself could also be a suspicious circumstance. My lord, there I'll rely on. So here the earlier authorities were, this is reported in 2009, 3 SCC 687. Para 14 onwards, madam. The legal principle, has your lordship found it? The legal principles in regard to proof of a will are no longer res integra. A will must be proved having regard to the provisions contained in clause C of section 63 of the Succession Act 1925 and section 68 of the Evidence Act, in terms whereof the propounder of the will must prove its existence by examining one or more of the attesting witnesses. Where, however, the will of the validity of the will is challenged on the ground of fraud, coercion, or undue influence, the burden of proof would be on the caveator. In a case where the will is surrounded by suspicious circumstances, it would not be treated as the last testamentary deposition of the testator. This court in H. Venkatachalya Iyengar versus B.N. Thimma Jamma opined that the fact that the propounder took interest in the execution of the will is one of the factors which should be taken into consideration for determination of due execution of the will. It was held that one of the important features which distinguishes a will from other documents is that the will speaks from the date of death of the testator, and so when it is propounded or produced before a court, the testator who has already departed the world cannot say whether it is his will or not. and this aspect naturally introduces an element of solemnity in the decision of the question as to whether the document propounded is proved to be the last will and testament of the departed testator. In Venkatachala case, it was held that the propounder of a will must prove that the will was signed by the testator in a sound and disposing state of mind, duly understanding the nature and effect of the disposition, and he put his signature on the document of his own free will. Two, when the evidence adduced in support of the will is disinterested, satisfactory, and sufficient to prove sound and disposing state of the testator's mind and his signatures as required by law, courts would be justified in making a finding in favor of the propounder. Three, if a will is challenged as surrounded by suspicious circumstance, all such legitimate doubts have to be removed by cogent, satisfactory, and sufficient evidence to dispel suspicion. In other words, the onus on the propounder can be taken to be discharged on proof of the essential facts indicated therein. And then at paragraph 17, my lord.
Yes.
Paragraph 17, my lord, another judgment is quoted, that is Niranjan Umesh Chandra. My lord, just the relevant portion. Within 17, para 17, there's para 34, which is quoted. There are several circumstances, there are several circumstances which would have to been held to be described by this court as suspicious circumstances when a doubt is created in regard to the condition of mind of the testator despite his signature on the will, when the disposition appears to be unnatural or wholly unfair in the light of relevant circumstances. Three, the propounder himself takes prominent part in the execution of the will, which confers on him substantial benefit. So first, he takes a substantial role in the execution of the will. Second, he reserves substantial benefit for him. And coupled with this, my lord, he keeps it a closely guarded secret, which is the question of delay. So if we juxtapose all these circumstances, then it is shrouded in suspicious circumstances, my lord. And 234.2, it says that disposition appears to be wholly natural or wholly unfair in the light of the relevant circumstances is also something which I addressed on the last occasion, my lord, that the house was only a lifetime interest was created in the house. If your lordship would recollect.
Yes.
Only a lifetime interest was created in the house. And the arbitrator had clarified that no, after the death of the alleged testator, it will be alleged Shruti Devi Bauri, it'll go on to all the sons. And that was something which was discarded by the trial court, holding that section 14, in the teeth of section 14 of the Hindu Succession Act, that award itself would be illegal, which I had already addressed, my lord. Lord, I'll just quickly show the relevant portions. My lord will kindly have the I'll just quickly show those relevant exhibits, my lord, DW. Perhaps your lordship had marked that it's in the C file again, my lord.
Yes. Exhibit 1 is the will.
Exhibit 1 is the will. Your lordship perhaps has the PWs. The DW start from 73 of the LCR.
Yes.
Page 73, the DW exhibit start, my lord. The first document at page 74 is that arbitral award passed by Sri C.L. Chanda. Now here, page 77 is the relevant portion, my lord.
Yes, on the other day it was pointed it out.
So therefore, my lord, this had clearly said that you will only have a lifetime interest. So if you had only a lifetime interest, my lord, why would she even create a will in respect of that? That is where I try to draw this other point too, that when the disposition appears to be unnatural and wholly unfair in the life, because this arbitral award was only, had created only a life interest, and in fact, it was clarified also by a separate letter, my lord. That is at page 84. The arbitrator clarified also. There's only life interest that is vested on Mrs. Nandalal Bauri.
At page number
84.
Yes.
The second paragraph. Regarding the issue about allotment of land and bungalows situated at Borbari, Dibrugarh, it has been expressly clarified in page 4 of my said award that Mrs. Nandalal Bauri will enjoy this property till she is alive only, and after her death, it will automatically become the property of all the four brothers, so and so, so and so, and so on. So that clarification had also come. Now, last document I'd like to show is Exhibit 6, my lord, which begins at page 87, my lord. The relevant portion is at page 89. This is his application for mutation, my lord. At the top of page 89, your lordship finds by right of inheritance. And then the remarks your lordship finds, the applicant is the only son of the landholder who has the right of inheritance, hence mutation may be granted. My lord, if there was a will, my lord, and this continued till 1998, when revenue board proceedings, appeals, remand, everywhere, nowhere he again claimed on the basis of the will. So therefore, it is clear that he had kept it a closely guarded secret for 10 long years, which itself is a suspicious circumstance. Now, page 91, in fact, there is also a discrepancy regarding Dag and Patna number in the will and this. Page 91.
It is the copy of Jamabandi Para.
Yes, it's the copy of the Jamabandi, column number 4. Ukto Moja Warder, Duho Unoponsas Nong Miadi Pattar, Sariko Pas Nong Dage, Sudholesa, Hatho Pundor Nong Dage, Sarikota Sarilesa, Mut Sarikota Unnoislesa. But the Patta number shown in the probate and the will is 245. And village is different. Here it's shown as Jalan Nagar, and this is Gabur Bothar at serial number 3.
Page number?
Page number 91. 91 itself. So column number 3, the Gaon is shown as Gaburu Pothar. And
You were referring to.
Page 91 of the DW exhibits.
Yes, got it.
That's the Jamabundi.
No, regarding the will.
Oh, will, Malo. Will is at page 17 of the petitioner, page 17 of that same bunch, perhaps. Of the petitioner witness, same C5. 172
70?
17. 17 of that C file itself. PW exhibits.
Oh. Discrepancy relates to that number or
Patta number 245 and revenue village.
The schedule of the application is that on no, schedule of the will it is that Patta number 245.
But it should have been it is 249 and the village is Gabharu Pothar and not Jalan Nagar. In fact, my lord, I don't have the copy of the order, but I've checked the records, my lord. In fact, we had made an attempt to even examine the signature. We filed an application saying that the signature should be compared, and we filed an application to call for the records of a bank where the signature of Stuti Devi Bauri was there. That there they objected, saying that we do not admit any signature. So when there could not have been admitted in specimen signatures, it could not have, it was not sent for forensic examination. So what I'm trying to say is, burden of proof was already on them. They did not attempt to prove the signatures by any forensic examination. When we made an attempt, they created a dispute saying that
No, they have proved this will
my lord,
as per the procedure prescribed in the act itself.
well, 63 and 68, of course, my lord. But then ultimately, the other circumstances your lordship will take note of, and also the delay part.
Okay.
I'll reserve my right of reply, my lord, once they
Yes.
come.
Yes.
So, I'm grateful to your lordship. The plaintiff adduced evidence PW1 and PW2. Both the two attesting witness.
Yes.
Just I'm referring to two paragraphs to show how far the personal activities of the propounder is there in respect of drafting.
Yes.
Only for that purpose. Page 1 to 5, the record memo.
Yes.
My learned friend read out paragraph 11. The leave of your honor, I'm again reading paragraph 11 of PW1.
You were referring to page number?
Page 3, internal page 3, memo page. That is from page 1 to 5 is the PW1.
1 to 5, yes.
Within which internal page 3, paragraph 11. What does now my friend referred to before your lord? Evidence of PW1. Page 1 to 5.
Paragraph number 11.
Yes.
Yes.
That somewhere in the first week of February 1987, while I was in the residence of Dr. Manohar Pauri, my mommy Suti Devi Pauri expressed her desire that she wanted to transfer her land and bungalow situated at Dibrugarh in favor of her son Dr. Manohar Pauri. This sentence is the concern of the testatrix at Dibrugarh. When all were talking as such, Dr. Manohar Pauri also appeared in her room and requested Dr. Pauri to present that to prepare the will of the mummy. Thereafter, both of us went to the chamber of P.L. Agarwal Advocate at Moti Loya Road in Sutia and requested him to come along with us to Dr. Pauri's residence. Dr. Agarwal, that Mr. Agarwal, being a friend of Dr. Pauri, came along with us, talked with my mummy in respect of her will and received instruction, etc. After a couple of days on 10th February, my mummy executed the will. So the thing is, this will was prepared at the instruction of the testator by the learned advocate. Only the negotiation took place by the son. What will be its implication? That I will try to place before your honor based upon the judgment. How far it will be amounting to the taking part, or in its true sense, active taking part by the person who has got interest over the will. Because admittedly the will was given bequeathing the property in favor of this statement. That is the plaintiff before your lords. How far will it be? For this particular purpose, I will try to place before your the judgment. Now I am placing before your the evidence part. Then the most important part is in respect of cross-examination. Your lordship kindly look into cross-examination dated 31/8/2006.
Yes.
The first paragraph, I am just giving the first paragraph, second paragraph. Prior to the business of tire, I was doing alone crushing business then. Earlier, both the parties used to live at Ages Road, Dibrugarh. The deceased Suti Devi Badi also used to live there. After separation, Suti Devi testatrix started living at Kinsukia with her son Dr. Manohar Baidi sometime in the year 1975-70. This sentence is a bit required because of the fact that one question was taken by the dependent appellant before your lordship, that is relating to jurisdiction point. Because the property situates at Dibrugarh, but the application was filed before the Tinsukia. Based upon section 276 that I placed before you. Thereafter, that then next paragraph, I'm coming to the testatives made up her mind. Has your lordship got?
Yes, yes.
The testatives made up her mind to execute a will either in the last week of January or first week of February 87. She expressed her intention to me alone. Within a short time, the petitioner also arrived there, and then I disclosed the intention of his mother regarding the execution of will. The first discussion with the deceased regarding the will took place in the evening hours. After 2-3 days, myself, accompanied by the petitioner, went to our lawyer, C.T.L. Agarwal, situated at Moti Lawyer. We met him in the evening. Then the lawyer visited the petitioner's house and talked to the testator. The will was finally executed on 10/2/1987. I was a frequent visitor to the house of petitioner, and I also know about the execution of the will. Hence, I was requested to be present at the time of execution of the will. The will was signed in the evening. I also read the will before becoming a witness. So the thing is, this evidence should be the evidence of chief. Instead of the same, this evidence has been taken in by your prosecution. Your lordship know it very well that if any positive evidence is coming forward in on the basis of prosecution, this is amounting to admission on the part of the party who is adducing evidence on that particular basis. This should never be, but this should have been hardly in the form of suggestion, where PW1 should say not a fact. But here is the fact which has been stated. This should be the statement of PW1 in respect of examination of chief. But instead of the same, this has been taken because of the fact that I placed before your honor that PW1 defendant specifically stated that he does not have any botheration about the will. He stated in written statement as well as in the evidence that I will come up. Before that, I must have to satisfy your lordship conscience in respect of discharging the provision of section 63 and 68. Section 63 of the Inner Succession Act and section 68 of the evidence. This is the evidence of PW1 on the basis of which the will has been duly exhibited. Then I am coming to PW2. That is page 6. So examination in chief, I don't want to read out because the same things have been repeated. Then I'm coming to cross-examination dated 31/8/2006. Probably on the back page.
Yes.
I know the petitioner since 1981. Both of us are members of Lions Club. 3 days prior to the preparation of the will, Dr. Bauri, accompanied by Gopal Agarwal, Sri Gopal Agarwal, came to my chamber and requested me to prepare a will as per the wishes of the petitioner's mother. I accompanied them to meet the testator. The will was drafted by me and took 2 days to prepare it. I also got it typed. To my memory, the will was typed by myself. Either it was typed in the morning or in execution of the previous evening. Thereafter, it was taken to the house of the petitioner, where it was signed by the testator and witnesses. The thing is, if I, the plaintiff, have given instruction to the learned advocate, the learned advocate could have drafted. Learned advocate did not do it. Learned advocate had come to the testator. Learned advocate took the instruction from the testator and prepared the same and obtained the signature. There is no scope of taking any part or any participation or any active participation so far more further. Clearly, it proves and establishes, and these are the cross-examination, not chief. This is your lordship, kindly take note. We again and again the basic principle that cross-examination at the time of cross-examination we should be very much restricted towards the questions because of the fact that this will go as admission against me. So these are the clear case where the entire factor has come up on the basis of admission. The evidence of PW3 is matter immaterial. Now coming to the defense case.
Yes.
Probably I talk for.
Okay. After 5 minutes.
Yes, sir. There are two written statements. One is by defendant number 1, 2, 3, and another is by defendant number 5. I am concerned with defendant number 1, 2, 3 because defendant number 5 has not come forward to court. So the written statement by 1, 2, 3, it is page 8.
Yes.
No, sorry, page 4. Page 4 is for written statement by dependent number 5, and dependent number 1, 2, 3 is sorry, page 4. 5 to 11 is 5 to 5. We are concerned about dependent written statement by 1, 2, 3 because he contested, dependent number 3 contested.
That is at page number
Page number 4.
4 of the
Else here.
A5. A5.
Huh?
A5.
A5.
yes.
Your Lordship kindly turn to paragraph 3. That the contents of paragraph 3 and 5 of the petition that Shruti Devi Bauri executed a will dated 11 to 87 being her last will is specifically denied, and as such, the petitioner is required to prove the same in due legal manner. It is further submitted that no will has been executed by Srimati Shruti Devi Bauri, and the legality as well as the validity of the will as well as the appointment of the petitioner as the executor of the will are also denied, requiring the petitioner to restrict proof thereof. Now, most important is paragraph 8, that the contentions of paragraph 8 of the petition relating to filing of probate case number such and such before this court and the dismissal of the same being the matters on record are admitted. But, however, the contents of paragraph 9 of the petition that the alleged will is lying in the court is not known to the answering opposite party and hence to be proved. So, the defendant at the time of filing the written statement even did not have gone through the will. So, this particular written statement has been filed based upon imagination. Your Lordship knows it very well that as per the normal procedure, the moment defendant enters appearance, the first right which is accrued by the defendant is to pray for inspection of the original will. And immediately the direction is given for the purpose of inspection of the will. This is the normal common procedure. And after inspection of the will, only the date will be fixed for filing the written statement. That's the normal procedure, because otherwise how the defendant would be aware about the contents of the will and or its original. But here the thing is, he even did not know where the will is lying, meaning thereby that he has not got any necessity to inspect the will. His only answer, only conclusion, only inference is that he knows about the will, about the existence of the will. For this reason, he has decided not to inspect the will. This is the written statement. Then paragraph 10. That as regards the contents of paragraph 11 of the will, it is submitted that the testator did never made any will, nor she had the right to make any will in respect of the property in question. That as such, the question of executing any will in good health and sense does not exist. That the contents of this paragraph that the testator was in good health and sense is required to prove the same in due legal manner. Your Lordship knows very well the provision of order it will see. Evasive denial and specific denial. And Honorable Supreme Court on repeated occasion told that defense right is there, defense obligation is there, whether he will specify the defense in a positive way, that is in a specific denial or evasive denial. Written statement, practically I may be excused in respect of the will matter. The written statement should be confined in respect of its existence and or its execution. Nothing more, nothing less. But here the thing is, he put the plaintiff to the strict proof. Obviously, section 63 and 68 is there on the part of the plaintiff to prove the same. So this does not have any relevancy in respect of the concern. Now, hardly the last page, that is continuation of paragraph. This is a very big paragraph. Absolutely on the last page, paragraph 11, internal page 6 of the written statement. That the petitioner having failed to achieve, that is just last part 2 paragraph. that the petitioner being failed to achieve his goal resorted to another foul play, and with that in the end in view, has got his will falsely prepared and has applied for probate on the basis of the said will, fight probate case number ato, knowing the same to be false, fabricated, and concocted. Then, as per the terms of award, then he has already gone to the title chapter. So this is the written statement, based upon which the defendant has come up adducing evidence. Your Lordship now turn to the evidence of DW1. Only very short paragraph that I placed before your Lordship. Page 118.
Of C file.
Yes. The cross-examination dated 4/12/2008, 4th December.
Yes.
As per terms of the award dated 18/11/77, the property was allotted to my mother for a lifetime only, and after her death, the property will be devolved to all the four brothers.
Which paragraph you were reading?
The first paragraph of the cross-examination dated 4/12/2008. Cross-examination of DW1.
Yes.
The last page also, this is a very short. As per the terms, as your Lordship, as per the terms of the award dated 18/11/1977, the property was allotted to my mother for a lifetime only, and after her death, the property will be devolved to all the four brothers, which I stated in my affidavit in evidence. So, I have no concern relating to the existence or non-existence of the will in question. So that end the entire chapter. He has no concern about it. And in fact, the entire argument advanced by my good friend should have been the defense case. Your Lordship knows the entire basic principle in respect of the will is very, very clear. Plaintiff's claim is only the filling up form of section 276. 276 provided 1, 2, 3, 4 ABCD. What are the things to be contained in the claim? End the chapter of the claim. Then the defense has come out. In the course of defense, he should have to come out with the suspicious circumstance. Then PW1, PW2 should be the attesting witness who will prove the will. That chapter ended. Now comes to the concern of the plaintiff to satisfy the learned court in respect of the suspicion that has been made out by the defendant, either by way of fraud, misrepresentation, this, that, whatever the grounds that is available to the defendant. This is very plain, simple theory in respect of the will matter. That I will come up before your Lordship, the basic principles of law to this particular. Now, my learned friend referred to before your Lordship. Now the thing is, in respect of the conduct of the defendant prayed for obtaining an order for handwriting. That order was passed by the learned trial court. That order was challenged before this honorable court. And your Lordship kindly look into page 32 of the first file. This is the order of this honorable court, CRP 44 of 2007.
Yes.
Your Lordship kindly turn to the just last part, one paragraph in portion, that is operating portion of the judgment.
Page 38.
Page 35, look like that is the internal page 5. That is just last part, one page.
Yes.
Absolutely last paragraph. In the above view of the matter, as your Lordship got it, this petition is disposed of granting liberty to the petitioner to raise objection if so advised with regard to the signature appearing on the application form on their production info. Needless to say, if such an objection raised, the learned court below would examine the same on merit and take appropriate action. So the liberty has been given to them, based upon which they have come up with an application. That order was passed. Your Lordship, kindly look into the order sheet, page P, P for partner.
Is
P for partner. Chronological order sheet.
of the trial court?
Lower
Order
court,
of the trial court?
first file.
Order
Order
of
sheet.
the trial court?
Either trial court. In the trial.
Dated?
21st January 2008.
Yes.
I'm coming to the second paragraph because this is the only paragraph.
Yes.
That being the position, there is no admitted signature of the testative for sending the question document to the handwriting expert. A question document can be sent to the handwriting expert for comparison of the writing or signature when the author of the recourse to the provision of section 73 of the Evidence Act. So that chapter is ended here. My simple question before your Lordship is, the defendant is coming forward saying that this is not her signature. In that particular case, she should have been aware about the original signature of the testative. She must have certain document with her, which can produce before the court to establish the handwriting expert and section 73 can be attracted. The defendant has come forward without going through the written statement. The defense taken by the defendant is absolutely evasive and just for the purpose of filing the written statement that has been done. He has not taken any steps in respect of appointment of handwriting expert. The plaintiff duly discharged each and every owner which is lying with the plaintiff for the purpose of getting a degree in his case. This is total background, factual aspect of the matter. Now I'm coming to the points of law. What are the basic principles in respect of the case? For the particular purpose, first of all, some technical things which has been pointed out by my learned friend. I am placing before your honor the provision of section 90 of the Indian Succession Act. Indian. Indian.
Yes.
Sorry, no, okay. Yeah. The description contained in a will of property, the subject of gift shall, unless a contrary intention appears by the will, be deemed to refer to and comprise the property answering that description at the date of the testator, which all the time the language of the legislator is died possessed of. Today, I may execute a will in respect of the property which I belong today. But at the time of death, this property has been left out or I have already sold out and I purchase some property. What should be the contents of the will? Obviously, what I died possessed of. So to this particular respect, the property is never be the subject matter of the will. Now I'm coming to the question of title, which referred to by my learned good friend on constantly and repeatedly for this particular purpose. Straight away I'm coming to the judgment reported in 2007 volume 11. Supreme Court cases. Page 357.
Yes.
Paragraph 11. We noted herein earlier, the suit for declaration of title and injunction has been filed by the appellant inter alia on the allegation that the suit properties are joint family properties of HUF, of which the appellant and his two brothers. Has your lordship
Got it.
Hardyal Singh Dhillon and Harban Singh Dhillon mother Sujit Kaur and unmarried daughter Amarjit Kaur are members. It has also been claimed by the appellant in the suit that by utilizing the income from the ancestral agricultural land, various properties, including the suit properties, were acquired. Such being the allegations made in the plaint, which can only be decided on trial after parties are permitted to adduce evidence in respect of their respective claim. It is difficult to hold that only because probate of the will of late Kripal Singh has been granted, the suit for title and injunction must be held to be maintainable in law. It is well settled law that the functions of a probate court are to see that the will executed by the testator was actually executed by him in a sound disposing state of mind, without coercion or undue influence, and the same was duly attested. It was therefore not competent for the probate court to determine whether late Kripal Singh had or had not the authority to dispose of the suit property which he purported to have bequeathed by the will. The probate court is also not competent to determine the question of title to the suit property, nor will it go into the question whether the suit property is bequeathed by the will, were joint ancestral property, or acquired properties of the testator. This matter has been made more clear in the next paragraph, paragraph 12. This court, while upholding the above views and following the earlier decisions of this court, as well as with other high courts in India, observed in paragraph 15 at SCC page 515, which runs, paragraph 15. In Ishwar Deo Narayan Singh versus Kanta Devi, this court held that the court of probate is only concerned with the questions as to whether the document put forward as the last will and testament of a deceased person was duly executed and attested in accordance with law, and whether at the time of such execution the testator had sound disposing mind. The question whether a particular bequest is good or bad is not within the purview of the probate court. Therefore, the only issue in a probate proceeding relates to the genuineness and due execution of the will, and the court itself is under duty to determine it and preserve the original will in its custody. The Succession Act is a self-contained court insofar as the question of making an application for probate, grant or refusal of probate, or an appeal carried against the decision of the probate. This is clearly manifested in the fascicle of the provisions of the Act. The probate proceedings shall be conducted by the probate court in the manner prescribed in the Act and in no other ways. The grant of probate with a copy of the will annexed establishes conclusively as to this appointment of the executor and the valid execution of the will. Thus, it does no more than establish the factum of the will and the legal character of the executor. Probate court does not decide any question of title or of the existence of the property itself. There may not be any problem. My learned good friend cited before your honor the discrepancy between the tag numbers, these, that. No concern in respect to the probate. That question does not come in at all. So, relating to the argument advanced by my good friend that I have cited, now I am coming to the basic principle of law. I am placing before your honor, which has been started, AIR 1974 Supreme Court, page 1999. Your Lordship kindly turn to paragraph 30.
Yes.
It is true that wills are transactions of a nature which give rise to certain special consideration affecting their validity irrespective of the time, when, or the country in which they are made. Disputes over wills invariably arise after the testator's death, so that the alleged maker of the will is not before the court to deny the execution or to testify about the circumstances in which the alleged disposition was made. There are such possibilities of fraud and fabrication, particularly in cases of old and feeble persons, that courts have to be very circumspect in dealing with them and scrutinize the surrounding circumstances very carefully. This is not less, if not much more necessary in a country like ours, where misplaced confidence or unsophisticated persons is often abused by cunning and unscrupulous individuals, and perjury is not less frequent than elsewhere. One of us, then the earlier judgment has been quoted here. Then I'm coming to paragraph 14. Apart from general consideration emerging from the nature of a will and the circumstances which not infrequently surrounded the execution of it, there are other matters which are peculiar to the time and the society, and perhaps even to the person making the will and his or her family. Inferences arising from relationships between a testator and a legatee are certainly so dependent upon the peculiarities of the society or community to which the testator and the legatee belong. Their habits, customs, their values, their modes, their ways of thinking and feeling, their susceptibilities to particular kinds of pressures, influences, or inducement, that it seems very difficult to reduce them to a general rule applicable at all times and everywhere, so as to raise a presumption of undue influence from a particular type of relation. The only kinds of relationships giving rise to such presumptions are those contemplated in section 111 of the Evidence Act. Any other presumption from a relationship must to be acceptable, be capable of being raised only under section 114 of the Evidence Act. Such presumptions of fact are really optional inferences from proof of a frequently recurring set of facts, which make a particular inference from such facts reasonable and natural. If a particular situation arising from a set of facts which may raise a presumption elsewhere is exceptional or unusual here, there could be no question here of applying a presumption arising from a common or natural course of events. A suggested inference of undue influence would then be a matter of proof on the particular facts of the case before the court. This, we think, is the correct legal position. Then paragraph 15, short conclusion. The case before us would certainly not fall within section 111 of the Evidence Act. There is no presumption of law or fact in this country that a woman to whom a man is engaged to get married is in a position to dominate his will so as to override his own real intention. It is not mere influence but undue influence, which has to be proved by the party which sets up a case. In that, we think that a plea of undue influence were set up by a special plea, section 103 of the Evidence Act places the burden of substantiating such a plea on the party which sets it up. The defendant took up the plea before your lords. So the entire onus lies upon the defendant to establish under section 100. The burden of proof is not on the plaintiff, but on the defendant. Straightway I am coming to the current and latest judgment, which practically, I should say, that is, we used to refer to for either plaintiff or defendant, whatever the thing may be, for all purposes. Basic principle have been discussed. This is reported in 2023, volume 9, Supreme Court cases, page 734. Paragraph 10. Entire matter has been cut short, relying upon all the decisions, because this is the most current judgment as far as I can find out. Relying on, then I am not reading about these particular judgments because these are the all most important judgments which has been referred to by different courts on different occasions. Such and such, we can deduce, infer the following principles required for proving the validity of the execution of the will. 10.1. The court has to consider two aspects. Firstly, that the will is executed by the testator, and secondly, that it was the last will executed by him. It is not required to be proved with mathematical accuracy, but the test of satisfaction of the prudent man has to be applied. A will is required to fulfill all the formalities under Section 63 of the Succession Act. That is to say, the testator shall sign or affix his mark to the will, or it shall be signed by some other person in his presence and by his direction, and the said signature or affixation shall show that it was intended to give effect to the writing as a will. It is mandatory to get it attested by 2 or more witnesses, though no particular form of attestation is necessary. Each of the attesting witnesses must have seen the testator sign or affix his mark to the will, or has seen some other person sign the will in the presence and by the direction of the testator, or has received from the testator a personal acknowledgement of such signature. Each of the attesting witnesses has signed the will in the presence of the testator. However, the presence of all witnesses at the same time is not required. For the purpose of proving the execution of the will, at least one of the attesting witnesses who is alive, subject to the process of court and capable of giving evidence, shall be examined. The attesting witness should speak not only about the testator's signature, but also that each of the witnesses have signed the will in the presence of the testator. If one attesting witness can prove the execution of the will, the examination of other attesting witness can be dispensed. Where one attesting witness examined to prove the will fails to prove its due execution, then the other available attesting witness has to be called to supplement his evidence. Whenever there exists any suspicion as to the execution of the will, your lordship kindly take note of it. Execution of the will, it is the responsibility of the propounder to remove all legitimate suspicion before it can be accepted as the testator's last will. In such case, the initial onus on the propounder become heavier. The test of judicial conscience has been evolved for dealing with those cases where the execution of the will is surrounded by suspicious circumstances. It requires to consider factors such as awareness of the testator as to the content as well as the consequences, nature and effect of the disposition of the will, sound, hearted and disposing state of mind and memory of the testator at the time of execution. Testator executed the will while acting on his own free will. One who alleges fraud, fabrication, undue influence, etc., has to prove the same. However, even if in the absence of such allegations, if there are circumstances giving rise to doubt, then it becomes the duty of the propounder to dispel such suspicious circumstances by giving a cogent and convincing explanation. Suspicious circumstance must be real, German, and valid, and not merely the fantasy of the doubting mind. Whether a particular feature would qualify as suspicious would depend on the facts and circumstances of each case. Any circumstances raising suspicion legitimate in nature would qualify as a suspicious circumstance. For example, a shaky signature, a feeble mind, an unfair and unjust disposition of property, the propounder himself taking a leading part in the making of the will under which he receives a substantial benefit, etc. In short, apart from statutory compliance, broadly, it has to be proved that the testator signed the will out of his own free will. At the time of execution, he had a sound state of mind. He was aware of the nature and effect thereof, and the will was not executed under any suspicious circumstances. Each and everywhere, the language is at the time of execution of the will. This is the latest judgment I have tried to bring out before your lordship, which practically we used to refer to before each and every court, either on the part of plaintiff or on the part of defendant, because this is the basic principle. We should have to keep it in mind as an officers of the court as the for the particular purpose of satisfying the conscience of the court, whether this is coming up on that particular basis or not. Here in this particular case, I don't want to read out the story. The fact remains that the property was given to a second wife. The marriage was challenged. It was told by the son and daughter that he is not married to the testator, as such she cannot get it. The honorable court told that no matter whether she is wife or not wife, that cannot be the subject matter of the will court, probate court. So this particular principle is also covered, relying upon the original judgment of 1974. That also based upon the first judgment in 1959 Supreme Court, that each and every court used to rely upon that particular basic principle of discussing all these particular things. I am not going to so much back as on today, since this judgment is there before your lords. So this particular basic principle and question, yes, here in this particular case, both the two witnesses have come up and adduced evidence and faced cross-examination. At all, already I have referred to before your lordship that the defendant themselves put the cross-examination in respect of making out the positive plaintiff's case by way of proving the will, instead of taking out the denial that this is not, this is not, this is not. Because each and every occasion, the courts come out to the finding that the conscience of the court is to be made out on the basis of adducing evidence, so that some suspicious mind should come out. There is nothing before your lordship which has been bringing out by the defendant, because the case of the defendant that I don't bother about the will, whether it is there or not. Because I'm getting the property after the death of the mother, I become the owner of the property. So I don't have any botheration about the will in question. Now, the basic principles I am placing before your honor. One judgment. This is reported in 2008, volume 8, Supreme Court cases, page 463. This is also relating to the reference to point of limitation, paragraph 15. They are also the point last page.
Yes.
Similarly, reference was made to decision in such and such. Such and such reads as follows. Rejecting Mr. Dalpatri's contention, I summarize my conclusion thus. Under the Limitation Act, no period is advisedly prescribed within which an application for probate, letters of administration, or succession certificate must be made. The assumption that Article 137, the right to apply necessarily accrues on the date of death of the deceased, is unwarranted. Such an application is for the court's permission to perform a legal duty created by a will or for recognition as a testamentary trustee, and is a continuous right which can be exercised any time after the death of the deceased, as long as the right to do so survives and the object of the trust exists, or any part of the trust, if created, remains to be executed. The right to apply would accrue when it becomes necessary to apply, which may not necessarily be within 3 years from the date of deceased death. Delay beyond 3 years after deceased death would arouse suspicion, and greater the delay, greater would be the suspicion. Right, that one I am placing before you. Such delay must be explained, but cannot be equated with the absolute bar of limitation. Once execution and attestation are proved, suspicion of delay no longer operates. Your Lordship, my learned good friend submitted before your honor that I was aware about the existence of the will. For argument's sake, if I do admit, does it mean that I must have to come up with the will immediately set forth? I stated that I am the only son living apart my brother and sister. If I stated any false statement, I have to face the consequence with respect to false statement. But what about the question relating to that one and related to this one? All these documents have been forthcoming before your lordship for the purpose of establishing that I have not disclosed the existence of the will. But peculiar enough, the defendant has not made out a single case before your lordship that I was aware about the existence of the will. So that your lordship can come to the definite conclusion that yes, you suppressed anything or this is amounting to a suspicion. This is nothing but the question of some illusion which has been brought up by the defendant, not only in any court of law, but straightway before your lordship, to come to the conclusion that these are the acts of the plaintiff. To this particular respect, so again I am coming to the basic principles, also covering the point of limitation, coming to a basic bit further. This is reported in 2020, volume 12, Supreme Court cases at page 480. Paragraph 60. while considering the issue involved, the decision of this court in Paramjit Singh Kadampur is required to be referred to and considered in the said decision. This court considered the decision of the Bombay High Court in such and such, as well as in the decision of Madras High Court in such and such. In the said decision, this court referred to and considered para 24 of the decision of the Madras High Court, which reads as under. In a proceedings, or in other words, in an application filed for grant of probate or letters of administration, no right is asserted or claimed by the applicant. The applicant only seeks recognition of the court to perform a duty. Probate or letters of administration issued by a competent court is conclusive proof of the legal character throughout the world. An assessment of the relevant provisions of the Succession Act 1925 does not convey a meaning that by the proceedings filed for grant of probate or letters of administration, no rights of the applicant are settled or secured in the legal sense. The author of the testament has cast the duty with regard to the administration of his estate, and the applicant for probate or letters of administration only seeks the permission of the court to perform that duty. There is only a seeking of recognition from the court to perform the duty. That duty is only moral and it is not legal. There is no law which compels the applicant to file the proceedings for probate or letters of administration. With a view to discharge the moral duty, the applicant seeks recognition from the court to perform the duty. It will be legitimate to conclude that the proceedings filed for grant of probate or letters of administration is not an action in law. Hence, it is very difficult to and will not be in order to construe the proceedings for grant of probate or letters of administration as application coming within the meaning of an application under Article 137. This court approves the observation made in paragraph 24 of the Madras High Court insofar as the nature of the petition for grant of probate or letters of administration is concerned. However, this court did not agree with the finding that the applicant for grant of probate or letters of administration is not covered. In the aforesaid decision, this court also considered and referred to paragraph 16 of the decision of the Bombay High Court. Then paragraph 16 has been quoted. Under the Limitation Act, no period is advisedly prescribed within which an application for probate, letters of administration or successful certificate must be made. The assumption that Article 137, the right to apply necessarily accrues on the date of the deceased, is unwarranted. Such an application is for the court's permission to perform. The same thing has been more or less repeated. Therefore, paragraph 17. Therefore, considering the law laid down by this court in such and such, it can be said that in a proceeding, or in other words, in an application filed for grant of probate or letters of administration, no right is asserted or claimed by the applicant. The applicant only seeks recognition of the court to perform a duty. Probate or letters of administration issued by a competent court is conclusive proof of the legal character throughout the world. That proceedings filed for grant of probate or letters of administration is not an action in law, but it is an action in law. This is the observation of the Honorable Supreme Court quoting about the other statements and all these particular things. Then I am coming to basic questions of this, referring to this particular point also, pointing limitation as well as the right of the parties. It is reported in 2020, volume 17 Supreme Court cases at page 284. 2020, volume 17, Supreme Court cases, page 284. Paragraph 15.
Yes.
Recently, in Somir Kapoor versus State, the context was slightly different. The probate was issued by a foreign court. The executor sought letters of administration in Indian court under section 228. The court dealt with the objection of limitation and noticed, firstly, that such and such has ruled about applicability of section 137 for the grant of probate in first instance, drawing a distinction from the grant of probate and the recognition of that under section 228 of the code held as follows. It can be said that in a proceedings, or in other words, in an application filed for grant of probate or letters of administration, no right is asserted or claimed by the applicant. The applicant only seeks recognition of the court to perform a duty. Probate or letters of administration issued by a competent court is conclusive proof of the legal character throughout the world. That the proceedings filed for grant of probate or letters of administration is not an action in law, but is an action in law. See, same thing has been quoted in this particular paragraph 15 and 16. Relying upon all these particular judgment, this court has been pleased to AIR 2016 Guwahati as page 133. So, page 133. Paragraph 7. Relying upon all the judgments that I have referred to just now, learned counsel for the respondent further submits that the court of probate is only concerned with the question as to whether the document put forward as the last will and testament of a deceased person was duly executed and attested in accordance with law, and whether at the time of such execution the testator had sound disposing. The probate court does not decide any question of title to the or the existence of the property itself, or for that matter, rights between the parties. The question as to whether a particular bequest is good or bad is not within the purview of probate court. The petitioner never raised any objection as regards genuineness of the will and the state of mind of the testator. Then the submissions have been made and the argument have been noted on that particular basis. Then I am coming to paragraph 10. Suppression of material facts on the basis of which the proceedings I have made before the mutation department without disclosing the will. Paragraph 10. On the issue of suppression of material facts as contended by the learned senior counsel appearing for the petitioner, it is necessary to refer to section 276 of the Act. Then section 276 has been quoted. This court has also gone through the other paragraph 11. Then paragraph 12. In the case of certain 1992 Madras, relied upon the judgment of Madras again, which has been already referred to before Your Honor, and based upon which the argument has been made. Based upon this entire thing, entire conclusion has come up in paragraph 19. I have perused the decisions relied upon by the learned counsel for the respondent. In the case of Chiranjeev Lal versus Atto, the apex court in paragraph 15 has observed as under. In Isabdev Narayan Singh versus Srimati Kanta Devi, this court held that the court of probate is only concerned with the question as to whether the document put forward as the last will and testament of a deceased person was duly executed and attested in accordance with law, and whether at the time of such execution the testator had sound disposing mind. The question whether a particular bequest is good or bad is not within the purview of the probate court. Therefore, the only issue in a probate proceedings relates to the genuineness and the due execution of the will, and the court itself is under duty to determine and preserve the original will in its custody. The Succession Act is a self-contained court insofar as the question of making an application for probate, grant or refusal of probate, or an appeal carried against the decision of the probate court. This is clearly manifested in the fascicule of the provisions of the Act. The probate proceedings shall be conducted by the probate court in the manner prescribed in the Act and in no other ways. The grant of probate with a copy of the will annexed establishes conclusiveness as to the appointment of the executor and the valid execution of the will. Thus, it does no more than establish the factum of the will and the legal character of the executor. Probate court does not decide any question of title or the existence of the property itself. The same thing has been concluded based upon this particular judgment. So the thing is, I have tried to place before your order that taking part is the matter of evidence. To this particular respect, the evidence is already there. I do not put it out. And the Honorable Court made on repeated occasions the apex of the I tried to place before on the judgment of the court. On repeated occasions told what is called active participation. And to this particular respect, if such defense is taken, then and in that particular case, that particular point is to be satisfied by the defendant first. After having the same satisfied, then only the question comes up to the plaintiff to satisfy before the probate court the consent that yes, there is a suspicion. But peculiar enough, each and every judgment pointed out absolutely in a needle way execution of the will, not later than. Here, my learned good friend submitted before your honor that delay causes suspicion. Delay causes suspicion for that particular purpose. The positive defense is to be made out before the probate court, on the basis of which the owner comes to the plaintiff to satisfy. The language is first owner is under 103 of the Evidence Act. The burden is entirely upon the defendant who make out that particular case. When the defendant make out that particular case, that question turns up to the plaintiff. Here the case is peculiar enough. The defendant did not know the existence of the will. The defendant has no concern about the legality and validity of the will. Whether the probate will be granted or not, that is also not any concern of the TW1. So the argument advanced today is absolutely German as of the present. Now one simple argument has been advanced by knowledge referring to Order 9 Rule 4. I don't know, because the fact remains that under Order 9 Rule 4, it is the concern of the party either to file a miscase or to file an independent suit. Order 9 Rule 4. Where a suit is dismissed under Rule 2 or Rule 3, the plaintiff may, subject to the law of limitation, bring a fresh suit, or he may apply for an order to set aside this suit. So the thing is, once the case was dismissed for default, thereafter, instead of proceeding with for restoration under Order 9 Rule 4, the plaintiff decided to file a fresh suit. There is no question of limitation, so that does not make any bar in respect of proceeding with the case. So to this particular respect also, I think there is nothing to challenge the legality and validity of the will in question on the basis of which the case has been made out before your lordship in a true sense, either on the part of the plaintiff or on the part of the defendant, to make any doubt in the mind of the probate court on the basis of which the probate can be the application for grant of probate can be refused to this particular thing. Just 1 second. So I may be excused. I'm placing before your lordship the judgment of 2023 volume 2 Indian civil cases, Calcutta High Court, page 693, paragraph 5, because I don't have that copy. If your lordship kindly excuse me, paragraph 5, where it has been specified what is the meaning of the term propounders active participation. Paragraph 5. I may be excused that I lost my copy. 290. 690.
You have already answered this point.
Yes, Your Lord.
In the latest judgment, you have referred to
Yes.
that
2020.
unjust disposition of property is also one of the suspicious circumstance. But how you will address this issue?
That is 2023.
Yes.
And in that particular case, the suspicion is not the subject matter, and property is not the subject matter. That has also been discussed in the judgment itself.
Yeah.
At no point of time, the probate court will look into whether the petitioner has the property or not, whether the property will ultimately go to the legatee or not. The probate court can never put this question, nor that will be the question for consideration. That has been decided each and every occasion by the Honorable Supreme Court. In each and every judgment that has been considered, the title is not the subject matter of the probate. Whether the property is in existence or is not in existence, no matter. Section 90 of the Indian Succession Act also provides that particular thing. If at the time of death I don't have any property, no property will go. But will the probated? Answer is yes. Even I bequeath the property during my lifetime. I don't have any property, but I executed a will. Whether the will be probated? Answer is yes. For this particular reason, the property is not the subject matter only for the purpose of probate, but property is the subject matter for the purpose of assessing the stamp duty, because we are all supposed to pay a probate duty for the purpose of obtaining the probate. For
Yes.
this particular purpose, the procedures provides that the property is to be sent to the collector. Collector will make the valuation if the property is available and assess the valuation on the basis of which the probate duty will be paid. Nothing more, nothing less. Property is not the subject matter. For this, section 90 is made it very clear. And most of the occasions, it is also our experience, and I think your lordship has also the experience, that in so many occasions, after the grant of certificate, even application for amendment comes forward, that this property was left by the testatrix or testator, which was not inserted in the probate certificate. Your lordship kindly permit me to amend the same. In so many occasions, this has normally comes up, and those all amendments are allowed because of the fact that this property is not the subject matter of the probate. Only one question, that is taking part which is amounting to suspicion, that I have placed specifically from the fact itself that he only followed the instruction of his mother to bring the lawyer to the mother. Nothing more, nothing less. Not a single evidence has come up before this learned court that he took part in any other matter. Mother intended to execute the will. He brought the learned advocate to the mother. The learned advocate took instruction from the mother and executed the will. Placed before the testatrix, testatrix put signature in presence of both the witnesses, where there is no role to play on the part of the proponent.
Okay. Yes, Mr. Decker, any reply?
Yes, my lord. My lord, I'll take 10 to 15 minutes. I'll wrap up very quickly, my lord.
No, why 10 to 15 minutes?
My lord, I'll just answer a few arguments that my friend has raised. my lord.
Okay, start it.
My lord.
Start.
My lord, it's not very good. My lord, first, the judgments placed by my friend, my lord. I would say, my lord, the first judgment that I would like to respond to is the judgment of Kanwarjit Singh Dhillon, my lord, which is 2007-11 SCC 357. My lord. So the argument, if I've understood it correctly, is that the probate court is not concerned with the issue of title. It should not venture into the question as to whether the testator had a right over the property to execute the will. Kanwarjit Singh Dhillon, relying on Kanwarjit Singh Dhillon, the argument is probate court cannot go into the question of title. And therefore, it was not for the court to see whether Stuti Devi Bauri had the right to dispose of the property by the will. That is the argument, if I've understood it correctly, my lord. My lord, if that argument is to be appreciated, my lord, then perhaps your lordship has to set aside the judgment, because if your lordship takes up the judgment at page 14, my lord, page 12, Page 12 of the judgment. In fact, I had made this argument on the last occasion also.
Yes.
Paragraph 5. Now the points for determination in this case are, has your lordship found it? Page 12 of the memo, internal page 7 of the judgment.
Yes.
Paragraph 5. Now the points for determination in this case are whether the will annexed is the last will executed by late Stuti Devi Bauri and whether the said will was executed in a sound state of mind and health. Number 2, your lordship will mark whether Stuti Devi Bauri had the right to dispose of the subject matter of the will by executing a will. So that is precisely what the learned trial court has done. It has ventured into the question of title. It has gone as far as, and then at page 14, the lordship I had already shown, I'm sorry, page 14 onwards, that the award, even the award of the passed by the arbitrator was negated, my lord. So therefore, page 18, I'm sorry, para 19 onwards, it has precisely done that. It has gone into the question of title. So if this argument is to be accepted that going by Kanwarjit Singh Dhillon, the question of right or title should not even be touched, my lord, then on that very count itself, the judgment should be set aside. Now which is why I had submitted on the first day itself that the point for determination number 2 was uncalled for. Now, what is perhaps my submission was not placed perceived in the correct manner. I am not saying that you go into the question of Stuti Devi Bauri's title over the bungalow and the land that you have bequeathed. What I am trying to bring home is that Stuti Devi, this was not an allotment in the name of Stuti Devi Bauri, so therefore it will be highly unusual, unlikely, or implausible for Stuti Devi Bauri to sort of dispose of this property by way of a will. And that is precisely what the Supreme Court says, that would itself be a suspicious circumstance. I am not questioning the title, but I am saying that it is rather unusual for Stuti Devi Bauri to have executed a will in respect of this property, because she knew very well, because she was privy to that arbitration award, and she knew very well that there is only a life interest. So that is insofar as the judgment of Kanwarjit Singh Dhillon is concerned. Rather, it is a judgment that we seek to rely on, that the trial court has unnecessarily gone into the question of title and formulated point for determination number 2. Now, coming to that latest judgment of 2023, my lord. Now, my lord, the normal rules of burden and onus of proof do not even apply in a probate proceeding. Because, my lord, this ultimately the judgment that is passed by the court is a judgment in rem. And the will speaks from the grave of the testator, and therefore there has to be extreme caution on the part of the court while granting a probate, because the dead man cannot come and depose and endorse whether he has executed the will or not. And therefore, irrespective of whether how my defense is or whether my written statement has been up to the mark or not, the court has to venture into the question of suspicious circumstances, and it is always on the propounder to establish the same. Now, if your lordship takes up the 2023 judgment relied by my friend Malone, paragraph 10, I'll just read 3 subpoints. This was 2023 9 SCC 734. Paragraph number 10 was relied on. In paragraph number 10, your lordship will kindly have Roman 8, 10 and 11. 8, Roman 8 is whenever there exists any suspicion as to the execution of the will, it is the responsibility of the propounder to remove all legitimate suspicion before it can be accepted as a testator's will. In such cases, the initial on the propounder becomes heavier. Then 10. One who alleges fraud, fabrication, undue influence, etc. has to prove the same. Full stop. However, even in the absence of such allegation, if there are circumstances giving rise to doubt, then it becomes the duty of the propounder to dispel such suspicious circumstances by giving a cogent and convincing explanation. Now, 11, suspicious circumstances must be real, germane, and valid, and not merely the fantasy of a doubting mind. Whether a particular feature would qualify as suspicious would depend on the facts and circumstances of each case. Now, your lordship will see that whether it's a real, germane, and valid suspicion or the fantasy of a doubting mind. Now, and it would depend on circumstances. There is already a family dispute, my lord, because of which the matter is referred to arbitration, my lord. Arbitrator finally decides that this member gets this much, this member gets this much, and so far as the bungalow is concerned, that remains with the mother during her lifetime, and after that it'll go to all the brothers, my lord. Bypassing that arbitral award where he himself is a party, he goes to mutate his name, ignoring the award and claiming to be the only son. He fails in his attempt. Then thereafter, 10 years later, he suddenly comes up with a document saying, look, my mother has actually executed the will. So I may not be entitled as per the award or inheritance, but I'm entitled as per the will. And he offers absolutely no explanation why he keeps it a closely guarded secret, my lord. So now your lordship will assess whether it's a real germane suspicion or it is just merely a fantasy of a doubting mind. The properties are already embroiled in litigation, arbitral awards, mutation cases, etc., etc. 10 years later, out of the blue, they come up with a will, my lord. And so much precision, my lord. Your lordship has seen the cross-examination, my lord. This event happened in 1988, my lord. And 2006, the witnesses deposed with so much of precision that I went that time evening 5 o'clock. Thereafter, the propounder comes. Then we go together to the advocate. Next day, advocate. My lord, is it humanly possible, my lord? And lastly, my lord, active participation, my lord. We do not know what was the dialogue between the mother and the son. All we know is your participation is the idea happened in your residence. You went to call the lawyer who was your friend. You were present at that time of execution. And now, if this is not active participation, what would then be, my lord? Now, to dispel that active participation, pieces have been relied on where he says that it happened according to my mother's wishes, my lord. But that we cannot say. But events that it happened in your house, you went to fetch the advocate, you got him along, the advocate was your friend, and what is the subject matter of the will? The entire bungalow goes to you. So if this is not a germane suspicion, what is, my lord? And so far as paragraph 8 of my objection was relied on to suggest that I did not even go through the will and I just merely said that it's force, my lord. That stands countered by the cross-examination where he says that I saw the copy of the will and before filing my written statement, and that's how I did it. What I essentially denied was I do not know if the original is in the custody of the court or not. And so far as delay is concerned, my lord, one thing is very clear, my lord, though the Bombay High Court judgment was quoted, my lord, the Supreme Court eventually ruled that Article 137 is applicable. Article 137 is applicable, but when does time begin to run? That is not always on the date of death, it could be anywhere. Now, then it went on to explain that whenever the necessity arises, now, so much of it is being fought in the revenue courts. Did the necessity not arise then? And if the necessity did not arise, then why did you even file it in 1998? So if you filed it in 1998, naturally the cause of action or the right to apply must have accrued before that. And if the cause of action would have accrued before that, then the subsequent petitions pursuant to the dismissal for default would again be covered by Order 9 Rule 4, which is why it is said subject to the law of limitation. Have I made myself clear, my lord? 98 he files it. So naturally, the cause of action or the right to apply has to accrue before 98, my lord. The matters get dismissed for default one after the other, and he files the last of the application. Now, trial court says that the limitation would begin from the date of dismissal, which is contrary to Order 9 Rule 4, my lord, because Order 9 Rule 4 is saying that subject to the law of limitation, you can bring forward a new suit. And so far as handwriting expert's attempt is concerned, my lord, handwriting expert, what had happened was we got a few papers from the bank to say that this is available for comparison. They said we will not admit these documents, which is why the expert examination did not ever take place. My lord, I made a sincere attempt. I officially called for the records, but they disputed, and which is it basically was shying away from a forensic examination under 45. My lord. And therefore, no examination even under 73 could be done, my lord. So that should be.
Only one sentence in reply, that is first appeal is under provision of order 41 order 41 rule 33 of the code of justice. Just reading before your lordship only one sentence. The appellate court shall have power to pass any decree and make any order which ought to have been passed or made, and to pass or make such further or other decree or order as the case may require. And this power may be exercised by the court, notwithstanding that the appeal is as to part only for the decree and may be exercised in favor of all or any of the respondents or partners. So I have placed before your lordship the basic principle of order 41 rule 33. Whether the judgment was passed by the trial court, right or wrong, it is my subject matter. My subject matter is whether the probate is to be granted or not. That may be granted by your lordship. That is not the subject for the. That's what. Get to.
Obliged. Sorry for detaining.
Giving me opportunity to. But I'm grateful so that the matter has been done and I have given opportunity to make out my case.
Further data loaded for the appellant and Sir Sarangi loaded new counsel assisted by Mr. Gwen. Loaded
So far as item number 31 is concerned, madam.
Yeah.
No, my lord, the matter will be listed some other day. I will just receive the copy of first execution filed by the other side.
Which matter?
31.
Supplementary.
You informed the other side?
Yes.
Any objection?
No objection.
On the prayer being made by Mr. P. Katonier, Lorded counsel for the appellant, with consent from the other side, basis and list the matter on when
24th of January.
January. Okay.
Huh? 20? Yes. 23rd. Yes. No, this is okay. Thursday.
I did mention item
It will be 24 Saturday.
for the hearing matter. So it may be adjourned to you. And now nobody is appealing for the respondent, my lord. The last of it also non-appear. So we tried to contact, but we are not getting any contact number and nothing.
Okay, on the prayer being made by Ms. Use of Property, learned counsel for the appellant, basis and list the matter
It will keep on the 11th February.
11 February. Okay.
January and-
No, this is a old matter
Old
of
matter,
2015.
my lord. Meet in the January.
First week of January.
My lord.
First week of January.
The 7 January other case, my lord, fixed, my lord. 7, 9, large number of cases in, my lord.
Okay. 21st January. Yes.
Madam, I want to mention 30, item number 30, my lord. Today,
30.
uh,
The matter was already settled.
yes, sir.
Today is fixed for only for filing this petition,
Yes, sir.
affidavit.
But the other side is not cooperating, and she has got something to say. Only 2 minutes, my lord. And my party has come. She wanted to sign the agreement. but the other side is not coming.
Why?
On the last two occasions, we contacted receiving the order. We have sent it.
So when he will be available then?
He's just giving it.
Pardon?
He's giving it.
If he is not interested to pursue the matter, we will dispose of the petition on the merit. On the Hmm? Item number
30.
Regular process. No, probably.
the question is whether he is interested to settle the matter. Pardon?
I can take in.
You obtain an instruction right now. After 10 minutes, I will call you. We will otherwise we will fix the matter for hearing.
That will be
We will
better.
dispose of it on merit. After 10 minutes, you come back with instruction. Yes, next matter.
Wait, please, Your Lord.
Yes.
The petitioner hearing has approached this honorable court under Article 227,
Hmm.
challenging an order whereby the right to file written objection was closed, my lord.
Hmm.
My lord, before going to
So
that,
how many adjournments you have
my
taken
lord,
before the time court?
before going to that, I'll just show a few medical documents of the petitioner. Petitioner is a person who is blind. Thesis bubbly is a disease which was caused to him way back in 1997, and his eyes collapsed, and he's now no more having any vision.
No.
If your lordship would just allow me to take your lordship through the orders itself.
No,
When
not
how many-
necessary. You tell me how many adjournments you have taken before that
My
time.
lord may come to the order sheet which I have annexed. My lord will just see at page number 38.
You come to your synopsis.
Yes, my lord.
Count it. How many
My lord,
times?
there are 3 adjournments which he had taken. If your lordship may kindly see the order sheet for a moment, your lordship will
The
be
first one
pleased
is
to
on. First one is on.
First, we appeared on 22/3/24. That your lordship will find the order at page number 38.
Yes.
The respondent number 1 has entered appearance today by filing wakalatnama and pays for adjournment. Accordingly, date was fixed
On 29
29/5, my
24,
lord.
you remain absent.
My lord, no, we had appeared. Respondent number 1, Vikas Das, at page number 39, if your lordship sees, has prayed for adjournment to file showing grounds that was allowed.
Then
Now,
on
my lord,
1/8,
on 1/8,
2024.
the presiding officer was absent, and we had also
On who is
filed
that?
on 1/8, that is at page number 40, my lord.
Hmm.
The PO was on leave and we had sought for an adjournment. Now, your lordship will see my petitions which I had filed for seeking adjournment at page number 40.
Thereafter on 11/9/2024.
That's true, my lord. I'll just take your lordship through the orders for a moment. Now, my
No,
lord,
not necessary. You come to the next page.
my lord, may see my petition filed on 21/9 for a moment, my lord, at page number 64. The engaged counsel for the respondent begs to state that
No,
respondent number
after 11/9, you have taken adjournment on 21/9/2024.
Yes, my lord, on the similar ground which we had taken on 11/9, 10 days was only given to us, my lord. What adjournment we had sought is that the respondent number 1 is a visually impaired person and he has to always be assisted by his wife since the year 1997. And his wife's mother got ill and she's an 85-year-old lady, my lord. She got ill, she was going through treatment, and due to being pre-engaged with her mother-in-law, she could not take her husband to the engaged counsel and give. My lord will see, I have also annexed the documents of the mother-in-law of the respondent that your lordship will find at page number 48. She's an 85-year-old lady, my lord, and she was taken on an emergency on 5th of September. 5th of September, when she was taken on emergency, we had filed on 11th of September, we had filed an adjournment. The learned court below had only given us 10 days time. Even on 21/9, the mother was not well and they had informed us and he could not come, my lord. Being a visually impaired person, my lord, the respondent cannot even right now say whether the signatures of the will are correct or not. And moreover, my lord, it's a probate application. Until and unless objections are taken on record, and the misprobate is converted into a title suit,
No, no,
the
who
rigorous
is
implications of,
responsible for the same?
my lord, the rigors of CPC would, in my humble submission, my lord,
No,
will not
that cannot be for indefinite period.
No, my lord, that's what we want. Just one last opportunity, my lord. We may be allowed to file a written objection. If not, court will pass a strict order that if we do not file our objection, court may proceed as per law. Right now, my lord, the matter is fixed on 20th of this month, my lord.
Where is your last petition?
My lord, we'll see at page number 64, the petition. If I may be allowed to read what I have stated.
Not necessary. Then where is the written statement?
My lord, we have not filed a written statement as of now. My lord, we intend to file a written objection.
Sorry. We dismiss the petition.
My lord, may
Next
kindly
petition.
see, my lord, that
Sorry.
he is a visually impaired person, my lord.
Sorry.
My lord, may issue notice at that moment.
No. We dismiss the petition. Next item.
May it legal. My lord, by this petition, I have challenged the validity to order dated 5/11/2024, passed by the Civil Judge Junior Division number 1, and that you will also will find at page 18, and the relevant portion is at page 20, my lord. I am the tenant, my lord, and so far the respondent is concerned, he is the landlord. Last one, my lord, page 20. I have considered the submission of both the sides and have reviewed the case report.
So when the case was filed?
It was filed sometimes in the year of 2012, madam.
2012.
Yes.
And since then, how many years elapsed? 12 years?
12 years.
Yes.
That position is right, my lord. Even though the fact remains that from time to time I applied for calling the NJ case record, because until and unless the NJ case records are called for and produced before the court, I cannot adduce the evidence, because in that case I cannot prove that I offered the rent according to section 5(4) of the 5(4) of the Urban Area Rent Control Act as to tender of the rent, when it was tendered, and as well as whether I paid the process fee, whether I submitted the notices, etc., all these things. My lord, for this purpose, first of all, I am taking to your lordship at page 49. Page 49. This is the last order which has been passed. 49. Have you got it, my lord? May I read from top? Scene report, such and such, of NG assistant of the office of the Municipal number 1, Kamrup, Guwahati, is stating that out of 165 numbers of NJ cases which were called for, 43 numbers of the NJ cases have been traced out and forwarded to this court. However, the remaining numbers of misjudged cases are very old and not yet traced out. It is also submitted that search for the NJ cases is still going on. Report is tagged with the concerned office. My lord, it is not my fault, my lord.
No, as per High Court rules and order,
yes,
the office is supposed to keep the
record
NJ cases only for 3 years.
No, that is not applicable in this case, because it is applicable only in case of district record room. District record room. If the NJ cases are transmitted to the district record room, in that case the record room has to keep 3 years. When the cases are pending in the court, this 3 years limitation is not applicable. And for this particular purpose, my lord, may I take your lordship to section 395. It starts
395
of rules of civil court rules and order. My lord, first of all, I am taking to your lordship to 20. That is chapter 20. Chapter 20, chapter 20 deals with the district record. Very beginning, my lord. It deals with the district record.
You were referring to section or rule?
Well, for this purpose, my lord, the learned trial court has mentioned rule 396, but I am referring to 395, my lord. That your lordship will see arrangement of records in the record. Heading 395.
Yes.
Have you got it, my lord? Arrangement of records in record room 395. The records of a district record room should be arranged court by court, different rakes, but allotted for the records of each court whenever the number and disposition of the rakes permit of this arrangement. When the records are placed on the rakes, the component files should be grouped thereon according to the periods for which they must be preserved. Section 396. Now the learned trial court has referred section 396. My lord, these rules only are applicable in case the records are kept in the district record room. And for that one, the period is only 3 years. If the records are in the court itself, then there is no question of their destruction and of keeping the records only for 3 years.
So if the records were available in the court, then why the court did not call for the same?
I have shown the order, my lord, because they say that it is not traceable. For that one, I cannot be blamed, my lord.
But the observation made by the court is that you were taking time since long.
No, my lord.
In order to stay in the
Yes, my lord. Definitely, I have to file the applications if the records are not coming. If the NJ case records are not coming, in that case, what would be the alternative left with me, my lord? How I will prove my case, my lord, that I am not a defaulter and I complied with the mandatory requirement of section 5(4). So, by coming on this particular aspect, my lord, that the liability is only to keep the records for 3 years, that is not applicable in my case. And that is specific statement I have made in my petition, my lord.
No, you have also given the opportunity to produce the credit certificate, but
My lord, what kind of credit certificate, my lord? What kind of? That is only the challenge copy. Duplicate copy I have, I can produce. But production of the duplicate copy would not absolve me from the liability to prove that I offered the rent. I took the steps as provided under section
No,
4.
if the records are not available, then what is the course available to you?
My lord, because in that case, what I have read, in that case, my lord, your lordship will come to my petition. That your lordship will find at page 55. Para 6, directly, my lord. Before this, my lord, let us come to para 5. That be that is it may, the defendants are ready to file the evidence on affidavit by the defendant's witness, provided the plaintiff is debarred. During the cross-examination, to put the question as to tender of rent, the payment of process fee, filing notice to be served upon the plaintiff to withdraw the rent, inasmuch as such case cannot be proved by defendant only by calling NJ case register, process register, etc. So that is the thing, my lord.
The question is, can this...
My lord, no inquiry was made whether they are traceable or not, because the order I have already taken to your lordship the order dated at page 49, my lord. And they are trying to...
Mr. Bhatte, you tell me, can this kind of order be passed or this kind of prayer be made before the trial court, that plaintiff shall be debarred from putting
my,
any
my, my, lord,
cross-examination,
my lord, in that
putting
case,
any question in
yes,
cross-examination.
in that case, my lord, my right can be taken away by the mistake of the court.
So
Well,
is there any
no.
provision in the CPC that the court can bar the plaintiff?
No, there is no provision. But
Then-
whether there is the provision that I can be denied the right to for proper examination to my detriment.
So this is a strange pair. And you saw how the impugn order is perverse or illegal.
That's why, my lord, what I have pointed out. First of all, I took these steps. The learned trial court has come to the conclusion that I did not take these steps for calling the record. My lord, the order speaks otherwise. That is at page 49. Your lordship has already gone through that order, page 49. So whether I took these steps or not. Seeing the report, Assistant Officer Munship Kamrup, Guwahati, is stating that out of 165 number NJ cases, which were called for, 43 numbers of NJ cases have been traced out and forwarded to this court. However, the remaining 122 numbers of NJ case records are very old and not yet traced out. It is also submitted search for is still going on. What is the result, my lord, for such search inquiry? It is not the case that I have not taken the step for calling the NJ case record. That finding of the learned trial court is absolutely perverse. I did not take this step. What alternative is left to me, my lord? How I will prove that I am not a defaulter? Is strictly in accordance with section 5.4 of the Urban Area Rent Control Act. That is the main question, my lord. By production of the registers, my lord, I cannot prove those facts. So that my right cannot be taken away. Though I may not, though the plaintiff cannot be debarred, but if he puts the question during the cross examination, what would be my reply? I cannot. So that some kind of relief has to be given to me. I am ready to.
No, that relief was already available to you, but
What kind of relief, my lord? In that particular case, what kind of relief is available to me? In absence of the NJ case record, I cannot prove the tendering of the rent, the issuance of the notice.
Okay, we will pass the order. We'll pass the order. Yes, next item.
Article 29. My lord, I tried to withdraw, my lord.
Pardon?
My lord, I prayed that
Sorry.
I may be allowed to withdraw the.
Sorry.
Yeah.
We will impose pause if you further insist upon the
Sorry,
matter.
apologies, my lord.
Much.
May I please, your lordship?
Yes.
Lordship, this civil revision petition, my lord. The petitioners have challenged order dated 5/9/2024 passed by the learned civil judge senior division Tinsukia, my lord, whereby, my lord, the proposed amendment was allowed, my lord. Prior to that, may I take your lordship to a few background of the case, my lord. My lord, this suit was filed, my lord.
You come to paragraph number 8 of the order, impugn
My lord.
order. The trial court has observed that no prejudice will be caused to you
My lord.
if the pair of the plaintiff for amendment is allowed.
My lord. That is why, my lord, I just.
And there is a recent judgment of Supreme Court that every amendment should be allowed, which are necessary for determining the dispute between the parties.
Yes, my lord.
Yes.
Absolutely, your lordship, absolutely
Then,
correct, my lord.
then
My lord,
how the impugn order is illegal?
Kindly see, my lord, the issue regarding non-gender of necessary party, my lord. By
the filing this amendment petition, my lord, they want to bring someone else in place of the performer defendant, my lord, which we have objected. Kindly come, your lordship may kindly come to page 49, my lord. This is our written statement file, my lord. 49, my lord. First paragraph, last part. May I read it, my lord? There is no grandson of late Nilamba Thapa, Elias Lamba Thapa, named as Manoj Thapa, who is impleading as performer dependent in the suit. The answering defendants further submits that the suit is bad for non-joiner of all the successor in interest of late Nilamba Thapa, Elias Lamba Thapa. My lord, we have taken a specific plea that Mr. Manoj Thapa is not the legal heir of Lamba Thapa, my lord. If now, in place of Manoj Thapa, Manohar Thapa is allowed to be included, my lord, then we will definitely suffer, my lord. And in fact, my lord, in our another, my lord, the dependent number 3 and 10.
Show me the petition, amendment petition.
My lord.
That page number.
That starts from, my lord, page number 143, my lord. Oh, so I'm sorry, my lord. 129, my lord. Page 129, annexure 5, my lord.
Yes.
Yes, my lord. In paragraph 2, the plaintiff number 1, my lord, kindly see this petition is filed only by plaintiff number 1. Whereas there are three numbers of plaintiffs, my lord. Without taking permission as per order 1 rule 8, my lord, this petition was filed, my lord.
Whether you have pointed out this legal point before the trial court.
My lord, yes, kindly come to my objection, my lord. Paragraph 4, my lord. Page 144, page 144, paragraph 4 of my written objection, my lord.
Yes.
Regarding issue of non-general necessity, we have raised, my lord.
Where is the plane?
My lord, plane starts from, my lord, page 12, annexure 1, my lord. And my lord, kindly take note that this performer dependent is the own brother of the plaintiff, my lord, plaintiff number 1.
The petition starts from amendment petition page number.
Page number, my lord, 129, my lord. Annex 5, page 129.
So what is the pair in this petition? In which paragraph it has been mentioned?
My lord, may kindly come to page 139. The prayer starts from page 139, my lord.
139, it has not been mentioned.
My lord.
Only to allow the petition, but
Yes,
what is the pair?
there is no prayer, my lord. As above said. This much only.
So in which paragraph the contention was made?
My lord, regarding non-gender necessary party.
Yes.
My lord, at page 144, paragraph 4, my lord, of our objection, my lord.
No. In the petition.
Petition, my lord, they have not made any such. The plaintiff has not made any such. I am the defendant, my lord. I have raised the question.
That's all right.
My lord.
You have filed objection to the petition.
Yes, my lord.
So you are aware of in which paragraph of the petition the contention was made by the plaintiff?
Paragraph 2, my lord. Page 129.
Then you reply to the said paragraph in
My lord,
page number?
Page 144, my lord. Annexa 7, my lord, starts from page 143. Relevant portion is at paragraph 144, my lord.
Paragraph number?
Paragraph number 4, my lord.
So they have mentioned the name of the grandson as Manoj Thapa instead of Manohar Thapa.
Instead of Manohar Thapa, my lord. Own brother's name, my lord, they have mentioned as Manoj Thapa. My lord, I have made Mr. Manoj Thapa, who is my brother, instead of Manohar Thapa. Sorry, my lord. Mr. Manoj Thapa, instead of Manohar Thapa, who is my brother, my lord. A party. Later on, they want to rectify this. When the issue issue regarding, my lord, non-joiner of necessary party was raised, my lord. After this, my lord, this is totally afterthought, my lord. They come with this petition that no, by mistake we have made. Kindly see, my lord, this suit is filed in the year 2023, my lord. This rectification could have been done prior to issuance of notice, my lord. When the plea was taken, my lord. Now they want to.
No, is there any bar in making such a prayer after taking such a plea by the defense?
My lord, kindly see, this will give rise to fresh cause of action, my lord. My legal right will, there will, I don't have any, I will not have any legal right. Kindly see, my lord, as per order 9, my lord, or order 1, rule 9, my lord. After 1976 amendment, my lord, the suits can be dismissed for non-joiner of necessary parties, my lord. This was brought by 1976 amendment, my lord. So, my lord, if necessary parties, kindly see, this is partition suit, my lord. So all the legal years are required to be brought into the record, my lord, which they have not, my lord. And by
They have mistakenly mentioned the name as Manoj Thapa instead of Manohar Thapa. Then this amendment was allowed by the trial court. Then you were prejudiced thereby. Is it your submission?
Yes, my lord.
Okay, we'll pass out.
Not mistake, my lord. Not mistake, my lord. This is what they kindly see, my lord, their petition, my lord. At paragraph 2, when they came to know after a petition filed by the performer defendant, not before that. Paragraph 2, they have clearly mentioned, my lord. After filing of the petition, my lord. Okay. I'm reading.
Admission item 8.
Lord, last occasion your lordship had called for the records. According to the office notes, the records have not arrived. It was heard in part, my lord, with the execution matter, my lord.
Part Mr. BD data learned concept for the non-FTS for the respondent. Office note dated 7/12/2024 indicates that healthcare was called for from the learned from the Court of Learned Civil Justice number 3 complaint, but the same has not yet been received. Accordingly, it is provided that the learned transport for transmitting the record without further delay. This is the matter of when.
Not any date in January, my lord.
On 21st.
21st. Online.
Item 9. May I please, Your Lordship? Your Lordship, this matter has come up for admission, Your Lordship. Pleadings have been completed, Your Lordship. Your Lordship, this matter needs some deliberation, Your Lordship. So I pray that the matter may be taken up after vacation, Your Lordship, because there are many critical issues which need to be dealt with, Your Lordship. And the illegalities committed by the
so
state
many
respondent.
debts taken by the petitioner, and it was filed on 2021. And just after filing, August 2021, there was an interim order. The payment is stopped, and they are regularly doing their services without pay. So it should be disposed of, if possible, today.
No, I'm ready to hear.
Hey, there is no ground actually. His petitioner joined on the same day. That is 10/15. Another, that is respondent number 5, respondent number 6 joined at 10:25, and another respondent number 7, private respondent number 7, 10:30. This is the only the ground of seniority ground.
Okay.
And
come prepared tomorrow.
Your Lordship may fix the matter after vacation, Your Lordship. Your Lordship, tomorrow I have some difficulties, Your Lordship.
Day after tomorrow.
Day after tomorrow, I'll be out of station, Your Lordship. I have to take medical leave, Your Lordship.
So, in that 3rd January, Lord.
3rd January.
No.
Okay. As agreed by learned advocates of both the parties, there is a matter.
Much obliged, Your Lordship.
Item 10.
May I please, Your Lordship? My Lordship, the brief facts of the case is that, my Lordship, we are the writ petitioners, my Lordship. We are those destitute candidates, my Lordship, who participated in participated pursuant to an advertisement which was issued in the year 1996, my Lordship, and the selection list was prepared in the year 1997 for appointment to LP school teachers, my Lordship. Thereafter, my Lordship, due to some unknown reason that selection list was not published, a series of writ petition has been filed before the Honorable High Court. And the Honorable High Court time and again directed the government to take an appropriate decision on the matter, my lordship. Thereafter, pursuant to those order of the Honorable High Court, my lordship, some deliverance has been made, my lordship. That is page 224 may be seen, my lordship. Page 24, 224. It was a letter dated 3/10/2020, 2020, my lordship. That is the Director of Elementary Education has wrote a letter to the District Elementary Education Officer Hailakandi regarding may I read, my lordship, with reference to the subject cited above, I am to request you to that is eligible Justice S.K. Kar Commission report on the matter of selection of candidates of LP/ME school teachers during 1996 to 1997 at an early date to establish the authenticity genuineness of the proceeding book of the selection panel list as submitted by the DEO's report dated eligible, my lordship. So our grievance is that thereafter also on page 27, then on page another letter was issued, my lordship. Page 302 may be seen. Page 302. This is one additional affidavit which I have submitted. Page 302. That is letter dated 10 July 2019 also, my lordship, regarding the same matter. Page number 302, running page 302. Running page 302, which I have I have submitted to additional affidavit. Yes. And page 302. This is the letter which was issued by Additional Secretary to the Government Assam to the Director of Elementary Education Assam, Kahilipara. This is also regarding our the selection list of 1991, that is selection of candidates for appointment of 273 number of posts of LPME school teachers out of 591 in the panel list in Hailakandi district. In inviting a reference to your letter on subject cited above, I am directed to request you to kindly furnish the following information in connection with selection of candidates for appointment in 273 numbers of posts of LPME school teachers out of 591 in panel list in Hailakandi district by advertisement dated 27/12/1996 to this and at an early date. Whether the selection of candidates were properly made, all records relating to interview including mark sheet etc. may be furnished, whether the selection list was prepared and furnished to the appointing authority, if yes, copy of the select list may be furnished, and whether any appointment to the post in question was made during the period under review. If yes, details of such appointments may be furnished with relevant records, my lordship. So, my lordship, some deliberation was made by the respondent authorities to address our grievances, my lordship. In the meantime, we have also filed one representation also, my lordship, page 256 may be seen, my lord. Page 256.
several representation has been filed, my lordship. Page 251, my lordship. Page 251.
Yes.
22, and the last representation we have submitted on 22/1/2022, my lordship. It is on page 256. To the Honorable Principal Secretary to the Government of Assam, Education Department. This is our latest representation which we have submitted before the Principal Secretary. We have raised several contention in this representation, my lordship. First, we refer to the particular findings of the SK Commission, my lordship. The findings, my which I have annexed an excerpt copy of the SK Commission report, my lordship. Page 49 may be seen, my.
Yes,
my lord. It is regarding District Hailakandi. Some observations were made in the SK Commission report. Paragraph 45. MD Abdul Mateen Chaudhary deposed as the IS and in charge DEO. He introduced list of appointments since 1/5/1996 and the list of concerned appointing authorities. According to him, only 19 appointments were made in the district during the period from 1/5/1996 till date. His further statement is that 18 appointments were made to clear the backlog and there were 12 vacancies. Muhammad Isaq Ali Badboya, DI, stated that there were 495 vacancies, that some vacancies were filled up by adjustment as per departmental order and some 68 posts filled up by direct recruitments. The Treasury Officer, Sri Manik Lal Dev, stated inter alia that he had submitted summary particulars of teachers of different blocks of LP and middle school as well as those of higher secondary schools and high madrasa. That means, my lordship, from the statement of the departmental officers, it was clear that at that point of time, no appointment was made, no illegal appointment was made pursuant to that selection list, my lordship. That advertisement dated 1/5/1996. Now, another relevant portion of the report, my lordship, page 58 may be seen, my lordship.
yes.
58 para 70 may be seen. A recent order by Director of Elementary Education Assam communicated by memo number EMA such and such dated 29/9/2005 referring to government letter such and such dated 4/1/2002 and government order under memo number such and such 6/2005 directed regularization of 16 working teachers of ME, MB, ME and senior basic government senior basic schools in the district of Golaghat on the strength of decision of cabinet meeting held on 24/2/2005 regularizing services of 2,776 LP, ME, MEM, high school and higher secondary teachers of state who were appointed in excess of post during the period from 1/3/1991 to 30/11/1996 and which were inquired by one-man inquiry committee headed by C. Manoharan IAS and subsequently by task force district level screening committee. The copy of the order aforesaid was sent to DEO Golaghat with an annexure showing the district-wise breakup list of illegal teachers. The annexure is reproduced below. So, my lord, as per this annexure, my lordship, it is from 1990 where only 157 appointments were made, my lordship. And in the, it is serial number 15, my lordship. Serial number 15. Now, my lordship, page 85 may be seen. Page 85. Page 85, typed copy is annexure 4, page 84. This is the then advisory committee submitted the selection lead before the that is the committee constituted by SK Kaur commission report. So the selection list was submitted before the SK Kaur commission report on 31/10/2007.
So that is for the interfere with the policy decision of the government of Assam.
Yes, my lordship. Now I'm coming to that, my lordship. Now I'm coming to that, my lordship. The government of Assam, they have taken policy decision to accommodate illegal teachers. Those who were appointed between 1996 to 2001. The report, SK Kaur Commission report, clearly states that no appointment was made in the district of Hailakandi, my lordship. Selection list which was prepared, we were the candidates, we approached the Honorable High Court with different writ petition. Honorable High Court directed the state to take a decision regarding our fate, my lordship. And they have accommodated illegal teachers by stating that they were appointed between 1999 to 2001, whereas the report says that no appointment was made. So our grievance is that we have submitted representation before the respondent authority. Let them take a call regarding our grievances, my lordship, which we have submitted representation, that is the last next.
Then, yes, Mr. Sharma, we direct the respondent authorities to dispose of their representation.
Representation law.
Yes.
Yes.
But they can give it hearing also, my lordship, with opportunity of hearing they can give us, and we have annexed all those writ petition we have filed earlier, and the decision, my lordship, on the basis of those redaction by the Honorable High Court, they gave a deliverance, they have taken some steps, my lordship, for verifying the records, my lordship. So they let them do a logical conclusion of the matter. That is by giving our hearing.
So far as the representation is concerned, Lordship may direct to dispose of the representation. But their main prayer is that they are challenging the policy decision of the government.
Challenging?
The policy decision.
That policy decision.
The policy decision of court, High Court cannot interfere with the.
At least, my lordship, they can dispose of our representation.
Under the purview of the
With the time,
illegal appointment.
that is, my lordship.
Okay, Mr. Sharma, how much time will you take to dispose of the representation?
3 months, Lordship.
3 months.
3 months.
Okay, good pass down.
Yes,
Mr. Das. Yes. You receive instruction?
My lord, as per the instruction of my senior counsel, Mr. P. Dekar, my lord may allow us to withdraw our wakalat now. My lord may issue notice on the.
Acha. Mr. Das.
My lord, my impression is that the
Not interested.
appellant is not willing to cooperate. And showing this reason or that, he's avoiding it, my lord. So they will be given a last chance, my lord. On that day, it will be hard and disposed of, my lord.
So you want to withdraw the wakalatnama?
Item 11.
Please, Your Lordship, kindly see the last order dated 26/2/2024. The respondent authority, they were supposed to give instructions whether area amount is released or not.
Lordship, the amount has been sanctioned and the petitioner has also drawn the amount.
Furnish a copy to her. So the matter become infractus now.
Lordship, kindly sometime be given, we would like to take instructions from our client if she had received or not.
Yeah, the last,
Next Friday.
Lordship, the last page, Lordship will see that the headmaster has given the certificate and he has also given the signature that he has received the amount.
It's a short date, Lordship, just to confirm from our client.
Friday, next Friday.
Obliged, Lordship.
Or else, Tito.
On behalf of Ditul Das,
Council
Lordship.
appearing on behalf of Mr. Tito, then also heard Ms. Mosahari, standing counsel for the respondent. Sorry, producing a letter issued by the Inspector of School for District Circle, Dashboard, dated 16/12/2024, submits that the prayer being made in this petition has already been addressed by the respondent authorities. And as such, this petition becoming practice and contented to focus. That is, this learned counsel for the petitioner submits that done with some time for the there is according to law, register with the matter on Friday.
Obliged, Lordship.
Item 12.
Obliged.
Wait. But in this case, my lord, the pleadings are otherwise complete, my lords. The rejoinder has also been filed by me, and written submissions are also on record. I have placed them. But I pray that this matter be taken up for disposal on 23rd January.
23rd
January.
Yes, when you were here.
I'm for 3 and 4.
1, 2,
3 and 4.
One. And for rest of the respondent? 1 and 2. 6. Okay.
But in the meantime, if the other respondents, my learned friend for 3 and 4, 3 and 4 have already filed their affidavit. I have filed rejoinder there too. If the other respondents are desirous of filing affidavit, they can also file it.
They can file.
Good.
They can file. Heard Mr. A. Gangole, learned counsel for the petition. And Mr. Upaidhyay, N.N. Upaidhyay, learned counsel for the respondent number 3 and 4.
3 and 4.
3 and 4. And Mr. T. Upamitya for respondent number 3, respondent number 6. And Madam Mahto for respondent number 1, 2, and 6. 1, 2, 1 and 2.
5 is Board of Secondary. Board of Secondary.
Board of Secretary. Who is for Board of Secretary? Absent today.
Absent today.
Okay, none appears for the respondent number. Board of Secretary, respondent number
5.
5.
5.
5. Respondent number 5. As agreed by learned advocates of both sides, SSL list the matter on when?
23/1.
Oh, admission hearing.
Good.
In the meantime, respondent number
1 and 2.
1 and 2 may file their affidavit in position if so advised.
Item 14.
May I please lordship? So last order, my lord, the department is allowed to time for filing affidavit, my lord. Earlier, my lord, as per order dated, my lord, 2/4/2024, my lord, instruction was sought for, my lord. Matters, my lord, pertaining to monthly pension, my lord.
Lordship, we had actually submitted a proposal here, and that is pending in the finance. So on the last occasion, not on the last occasion, your lordship, order dated 2/4/2024, your lordship. Instruction was to be placed by the finance department. So we had already sent the proposal. matter pertains to whether the benefit of petitioner under the whole pension scheme.
Well, that issue has already been settled by this honorable court. Already been settled. Now they are to release the monthly pension and other pensionary benefits.
Also, finance department is not a party here.
They have to be made a party because they are the necessary party. Because here the instruction that the from the government side, the instruction that has come is that finance has raised certain queries for approval, as approval from the finance department was not obtained, but it will be ordered dated 20. Finance.
But as per the 2424 order, my lord, we have served the copies of the finance department.
As per?
2424, my lord. Two 424, my. Yeah, my lord, the
Since
department.
the submission of this proposal, more than 6 months elapsed.
Yes, my lord.
Yes, your lord. To the finance, because our instruction is that we have not received any further communication from the finance government.
Probably you call the standing council of finance department. Wait for some.
My lord.
Item 15.
Maybe. We have filed an interrogatory application, my lord, for leave of the honorable court for drawing of our salary, my lord. What happened in this case, my lord? We have challenged, my lord, the in the petition ordered at 4/3/2024 at page 31. My lord. In the main lead petition, we have challenged this petition, my lord. This order, my lord. By this order, by this order, last paragraph, my lord, in view of the pay stepping up order in respect of this Kogendra Das, graduate teacher of the Korea Higher Secondary School, hearing this office bearing this office number so and so dated demand is hereby.
You are reading paragraph number?
Last paragraph, my lord.
Last paragraph.
Page 31.
Yes. 31 or 36?
It is, my lord. It is 20, page number 20. Sorry, my lord.
Page number?
20, my lord. 20 of the interlocutory petition, my lord. Last paragraph.
Yes.
In view of the above, the pay stepping up order in respect of Sri Kogendra Das, graduate teacher of Korea Higher Secondary School, bearing this office memo number so and so, 2nd September 2013, is hereby cancelled, and the principal of Korea Higher Secondary School is instructed to refix the pay of the Kogendra Das with the effect from 1/1/2006. This order is challenged in the main read petition, my lord. And my lord, notice was issued. They have received the notice that it has not filed, my lord. But what happened, my lord? Our stepping up order is page 19, my lord. Salary step up order, my lord. As per special ROP, this is the order, my lord. Short order. The wide order, it is so and so, my lord. The Kogendra Das, this is the repetition, my lord. Korea High School is stepping up rupees 17,000 imam instead of 11,000 so and so. Sri Kogendra Das 80 is senior most Dilip Chandra Kolita 80 so and so, my lord. So, my lord, Dilip Kolita is the respondent number 9, my lord. Yeah. There is a dispute regarding the in-charge principal, my lord. There is several lead petition, my lord. Ultimately held that Dilip Kolita is senior most because he has the criteria, my lord. Because as per my law, my lord, as per Act, my lord, to hold a post of principal, my lord, one must be a graduate, my lord, both of them graduate, and having the teaching experience in the higher secondary school is 17 years, my lord. Dilip Kolita has 17 years. I have not 17 years because I was transferred from another school, my lord.
this particular criteria is not fulfilled for principal, my lord. It does not mean that I am junior to them. But for the holding the post of principal, my lord, 17 years in the higher secondary plus graduate, my lord. Both we are graduate or we are master degree holder, both of.
No,
So,
in Bodha school, what is the
subsequently, my lord, the honorable division bench held that the earlier school should be counted. But already order is passed against me, my lord. So he hold the post, my lord, the husband number of holding the post of principal, my lord. Subsequently, two other incumbent after his retirement, they holding the post. Now, my lord, I am holding post of principal in charge, my lord. Now I am holding from April, my lord. Problem is this, my lord. Now his direction is that I am now drawing on this bench officer, my lord. So I cannot prepare my bill, my lord, as a principal. Either earlier rate or new rate, my lord. So since my lord, April, my lord, without pay, my lord. I am submitting bill others teacher, but I am without pay, my lord. So my leave, my this petition by individual, I want leave of the court. I may be allowed to either draw in the earlier rate or the new rate, whatever may be there. Because without any money, I am serving, my lord.
no, without disposing of the writ petition, can we
Yes,
direct you to prepare your bill in the new rate?
That is why, my lord. If it is earlier, this is a recoverable provision is there, my lord, and there is pension is there, my lord. If earlier rate is there, my lord, then there's subject to outcome of the writ petition, my lord. If there is a excess payment into recovery, so my lord, that is interim, my lord. Other, my lord, I am going to resign in 2005, May, I think May, na? May, my lord, to this year. So, my lord, without money, my lord, I am serving and I am retiring, my lord. So either way, I will get money, my lord. Either old rate or new rate, my lord.
No, which rate is higher? Old rate or new rate?
Old rate, my lord.
Old rate is higher.
Higher, my lord. Stepping up.
Yes.
Without hearing after 13 years, my lord. After 13 years, my lord, this without hearing this order is passed, my lord. Holding that, Dilip Kolija was senior. That is not the seniority finding, my lord. Only finding is that I am not eligible because 17 years now is not there.
In that case, we can finally dispose of your writ petition.
Maybe, yes, my lord. That may be fixed, but till then, my lord, I am.
That's all right. We are ready to hear the matter. Yes, madam. Have you filed your affidavit?
Yes, sir.
Pardon?
I have the instruction.
You obtain instruction. We will hear the matter on Friday then.
Yes, my lord. Because, my lord, I am going to retire in May, my lord.
Yes.
I am holding the post of principal in charge. I have to prepare the bill, my bill. Where the writ petition is pending.
No, where is the bar in preparing your own bill?
Because, my lord, what rate, my lord? Because I have challenged that order, new order, my lord. If I prepare the bill, then it will affect, my lord. If lordship pass the order that I can prepare the bill for the so and so rate without affecting my claim, my lord, the writ petition, that will be served the purpose, my lord. Otherwise, my lord, in the verge of retirement, my lord, I would have paid.
That's all right. Therefore, it is better for you that the matter is settled for once forever.
Yes, my lord. But
as soon as possible.
Yes, my lord. So if
you obtain instruction on Friday.
Then, my lord, they want some time because 18 is not possible. Then, my lord, on 6 or 7, my lord, January.
6 or 7 January.
Yes, my lord. It is 1 week there, my lord.
Then we will not pass any order in the eye.
Yes, but
finally we will hear the matter and dispose.
My lord, if some handle is given that he can prepare as per procedure, my lord, then he can file.
That will also serve your purpose.
Yes, my lord.
Third Mr. P.S. Dekar, learned senior advocate, assisted by learned counsel for the applicant, that Madam Sharon P. Standing counsel for the respondent number.
One and three, your lordship.
1, 2, and 3. And madam, respondent number 6, AZ. AZ. This interlocutory application is preferred by applicant. State, however, that's for granting leave to him to draw his monthly salary on the basis of earlier stepping up order dated 2/9/2013, passed by the respondent number 2, or on the basis of order dated 4/3/2024, passed by the inspector of school Mulberry. Mr. Decker learned a senior counsel for the applicant submits that the applicant has challenged the order dated. Which order you have challenged?
My lord, page 20, 4/3/2004. Speaking.
The applicant has challenged the correctness or otherwise of the order dated 4/3/2024 in WPC number 2636 of 2024. 2024. And since then, he could not prepare his bill and serving in the school without salary. And therefore, Mr. Decker submits that the applicant may be allowed to draw his salary. The applicant may be granted leave to draw his salary either as per order dated 2/9/2013 or as per order dated 4/3/2024, passed by the respondent number. Ms. Terranty learned standing counsel for the respondent number submits that. What is your submission in this IA? No objection.
I don't idea of the either he can make it to
But if I don't have any updated idea, I'll find my date petition.
So in this IA,
he has no
so
objection.
let him
no objection in the IA.
let him draw his salary as per this order dated 4/3/2024.
Or earlier, my lord. Whichever
no.
is feasible, my lord.
No, you have challenged the earlier order.
No, no.
Which order? This order.
This order, 24 order, my lord. Since 2013, man, I'm drawing on that my lord, earlier order, stepping up. This is the my lord, 19, my lord.
So you would draw the as per this order 4/3/2024. Is there any bar?
There is my lord, he
have
himself
challenged
will
it.
have to be
Challenge it.
either way, my lord, both of either which is feasible, my lord, because they will verify the inspector again.
No, without disposing of the writ petition, we cannot say that which one is correct.
It cannot, my lord. It cannot. But subject to outcome of the pre-petition, my lord. If any drawal is made, my lord, then whatever he received, my lord, it is subject to the outcome of the writ petition.
4/3/2024.
4/3/2024 is a new order which has been challenged by us in this writ petition. And I am continuing the receive order in my lord 2nd September 2013. From 2013.
Madam, let him draw salary. As per order dated 2/9/2013.
Yes, madam.
Submits that she has no objection in the event of allowing the petitioner to draw his salary as per order dated 2/9/2013.
However, subject
to outcome of the writ petition.
Yes.
being WPC number 2636 of 2024. Where having heard the submission of learned advocates of both the parties, I have carefully got the report and also perused the order dated 2/9/2013 and the order dated 4/3/2024. It appears that the order dated 4/3/2024 is being challenged under WPC number 2636 of 2024. Take a note of the same and also considering the facts and circumstances of the record. This court is inclined to allow the applicant to draw his salary as per order dated 2/9/2013, who is of course subject to outcome of the litigation in WPC number 2636 of 2024 in terms of his IAS that's closed. WPC, actually WPC is not listed today. No order is required. Okay. Heard Mr. Decker, Lord Esteemed Counsel for the petitioner, instead of Mr. Adopti submits that some instructions are still awaited. And prayed for listing the matter immediately after reopening of the vacation. There is accordingly allowed listing the matter on
No. 10.
10.
Okay.
10. On that day, Ms. Adopti shall produce the instruction before this court.
For bail hearing, item 16.
Adjourn the matter for a date. Lordship, may take it up on Thursday.
As agreed by Lord
19th.
Advocate of both the parties, raises the wisdom Thursday.
19th. Item number 18 for hearing under order 41.
Medfield, Lordship. The present appellant is the defendant, Lordship. The substantial question of law I have formulated in page 4, Lordship. Suit was for specific performance of contract. In our written statement, we have taken an objection that plaintiff was never ready and willing to do his part of contract, Lordship.
Whether any issue was framed on that point?
No, Lordship. And the trial court did not frame any issue, Lordship. My objection is page 17, para E, Lordship. That the plaintiff have no credible plea in the suit.
Page number 17.
17, para E. That the plaintiffs had no credible plea in the suit for their readiness and willingness about their collection of money and due attempt made to perform their part and denial by the defendant. All such material pleadings and attempt are not duly explained in the plain, so they are not entitled to get the degree in the suit as prayed for under sound and reasonable judicial principles for their own conduct. In this case, what happened, Lordship, the plaintiff executed an agreement in the year 2016, and thereafter they could not execute the degree in time. So later on, again they have executed a deed of agreement incorporating plaintiff number 2. A third party was incorporated in that agreement, Lordship. And 2017 agreement that they have exhibited as exhibit 1, but 2016 agreement was not exhibited. So defendant exhibited that agreement. That earlier also they executed an agreement and they failed to perform their part of agreement. Then again the second agreement was executed, and in this case also within 3 months they failed, Lordship. So we have taken an objection that there is no readiness and willingness on the part of the plaintiff, but no issue was formulated. Lordship will find the issues in page 22. And from the pleadings in the plaint also, your lordship will find there is an uncertain clauses in the agreement that after boundary demarcation, after lordship Batwara, the share of land will be calculated. The area of land will be calculated, and as per that calculation, the sale deed will be executed.
So whether this no, though no issue has been framed on this point, whether at any point of time the learned trial court has dealt with that issue
Main issues,
regarding
lordship, issue 4 and
readiness and
5.
willingness.
Lordship, main issues 4 and 5. So issue number 4 was discussed in page 24. Paragraph 19, your lordship, page 25 will find that about the statement by the PW1. In last part of that para, lordship, PW1 stated in cross-examination that he had not mentioned any date about breach of condition of Bainama. PW1 stated in cross-examination that he was involved in a murder case, White Hailakandi PS case number so-and-so, and got anticipatory bail on 1/11/2017 from Honorable Guwahati High Court. PW1 denied in cross-examination that he was not present in his house out of fear of police arrest till the date of order passed by Honorable High Court dated 1/11/2017. PW1 stated in cross-examination that he did not serve any written notice to the defendant for execution of the deed. So we have taken another ground that no notice was served upon the defendant to do his part. So that was admitted by the PW1. PW1 stated in cross-examination that there was no specific date mentioned in the agreement. PW1 stated in cross-examination that he did not make any demand through notice to the defendant after obtaining NOC. PW1 stated in cross-examination that he did not make any demand through notice to the defendant for measurement of the suit land after issuance of NOC. PW1 stated in cross-examination that he could not say the period when the NOC got withheld by the Deputy Commissioner Hailakandi. PW1 stated in cross-examination that the first Bainama was executed only in favor of him and Imrana Begum Mojumdar by the defendant on 2010. It should be 2016, Lordship, on receipt of rupees 1,90,000 in advance. PW1 stated in cross-examination that the value of the land was fixed at the rate of rupees 8 lakh per kedar. PW1 stated in cross-examination that the period of Bainama was extended up to 31/1/2017. PW1 stated in cross-examination that within that period NOC was not issued, and thereafter second Bainama, that is Exhibit 1, was prepared on 4/2/2017. PW1 stated in cross-examination
Madam,
that
my question was whether at any point of time the
Lordship,
trial court has dealt with the issue of willingness or readiness of the parties.
trial court, after discussing all the plaintiff witness and defendant witness, came to a conclusion that defendant admitted about the execution of the Bainama, Lordship. That we are admitting that Bainama was executed, Lordship, but within that period, plaintiff never came to adduce, never came and said that
Time was essence of the contract.
Lordship, 3 months was given in the deed of agreement, Lord.
Then?
And that was overload. He did not serve any notice to the defendant, Lordship, that you come and execute the deed, Lord.
Is there any requirement of serving a notice?
Lordship, at least he should serve a notice to show that he is ready and willing to do the agreement, Lord.
No, is there any requirement of serving a notice?
But Lordship, from the evidence also, it did not come to conclusion that plaintiff was always ready and willing to do his part of contract, Lord.
Whether the first appellate court has framed any formulate any point for determination?
Yes, Lordship. Point was formulated. Point of determination, page 47. As because we raised that objection in paragraph 9 also, page 47, paragraph 9, we raised an objection.
That being aggrieved and dissatisfied with the said judgment and decree, the instant.
Yes, this issue has been dealt with
Yes,
by
Lord.
the first appellate court.
In point number 1, and our objection is that, Lordship, that point number 1 was decided perversely.
How it is perverse?
Lordship will find that issue was decided in para 14.1, page 50, Lordship. After discussing the section 9092 of the Indian Evidence Act, and thereafter findings given in para 1516, page 53. Only it was as we admitted our deed of agreement. Thus, the provisions of law contained in section 91 and 92 of the Indian Evidence Act read together would reflect that when the terms of a contract is reduced to writing by the parties are bound to abide by the same unless and until the same is rescinded or challenged on the ground of fraud, deception, etc. It also reflects that when the terms and conditions between the parties are so reduced in writing, then oral evidence would be excluded from consideration unless and until exceptional circumstances can be proved before the court. In the case in hand, the plaintiff number 1 as PW1 has submitted the agreement for sale dated so and so as Exhibit 1. Although the terms and conditions are not constructed properly, a combined reading of the said document would reflect that the terms and conditions between the parties were to the effect that thereafter terms and conditions were, Lordship, recorded. Then, Lordship, para 17 and 17.1, page 55. The plaintiff as PW1 has exhibited the aforesaid document as Exhibit 1 and the said aspect has been admitted by the defendant as DW1 in his cross-examination. The defendant in his cross-examination has clearly admitted receipt of a sum of rupees 4 lakhs from the plaintiff from the entire amount of rupees 8 lakhs as settled by the parties in respect of the suit land subject to variation of the actual quantum of land on its measurement. Similarly, the Exhibit 1 would reflect that if for any reason the NOC could not be procured, the validity of the agreement would remain valid till issuance of the NOC from the office of the Deputy Commissioner, Hailakandi. Although the parties were to discharge their respective responsibilities within a period of 3 months from 4/2/2017, the clarification recorded in page number 3 of the said deed would reflect that the period of 3 months could be extended till issuance of the NOC by the competent authority. Perusal of the Exhibit 2 reflects that it is on 6/9/17 the defendant procured the NOC from the office of the Deputy Commissioner, Hailakandi, to sell the suit land in favor of the plaintiffs. The document, that is NOC, corroborates the contents of the Exhibit 1. The defendant contended that the plaintiffs were not willing and ready to comply with their part and hence they are not entitled to the reliefs claimed for. So, Lordship, after discussing the decision of this,
How it is perverse?
now page para 18, Lordship, page 57. On meticulous scrutiny of the record, especially the evidence, it would reflect that the plaintiffs have made repeated demands to the defendants to execute the sale deed, but on one pretext to the other, it is the defendant who delayed the matter. So, after going through which evidence this finding was given, Lordship? There was no such evidence on the part of the plaintiff, and it is the suit of the plaintiff. He has to Lordship, prove his case. Defendant admitted about Exhibit 1, it is true, Lordship. But on the basis of
if the defendant admits the
execution
agreement,
of, yes, Lordship.
what remains there?
Only, Lordship, the Exhibit 1 was admitted. But Lordship, there is no readiness and willingness on the part of the plaintiff. So we could not execute the sale deed, Lordship. The PW1 in his evidence in chief has reiterated the same and in his cross-examination has retained the stand taken by him. The defendant's side could not rebut the evidence adduced by the PW1 party.
There is also concurrent finding of fact by both the court below.
Yes, Lordship. That is true. My suit was declared by both the courts, Lordship.
Okay, we'll see if the finding in point 4, point number 1 is perverse or
not.
Heard is heard so today, learned counsel for the appellant. Order reserved.
Apply.
Pending item 14.
Lordship, I just received an instruction, Your Lordship.
Yeah.
Since finance has raised a query, Your Lordship. So for addressing that query, a detailed report has been sought from the Elementary Education Department, Your Lordship. We had written Director of Secondary Education, Lordship, has written to the Director of Elementary Education, seeking for a detailed report.
The letter is dated.
Dated, 2026.
Oh, madam, already 7 months elapsed. That's the date of this order or date of this letter.
Lordship, my instruction is that we have not received any detailed report from the Elementary Education Department.
Who's for elementary?
Also, there'll be a different council for elementary.
Can you call it? But for something.
Mild, plus mild.
Item 19.
May I please, Your Lordship.
Yes.
The appellant is the plaintiff, Your Lordship. The suit of the appellant was dismissed and preferred appeal that was also dismissed, Your Lordship. The substantial question, Lordship, at page 11, Your Lordship. I propose 3 substantial questions, Your Lordship.
Plaintiff suit was dismissed by the trial court.
Lordship.
Thereafter, what happened in appellate court? First appellate court.
First appellate court also dismissed.
Appeal the order.
Appeal the order.
Decree.
Yes.
Judgment and decree.
I have formulated the substantial question of law number 1, Your Lordship. While dismissing the appeal of the appellant, the first appellate court amended issue number 4, and it did not remand back to the trial court, and did not get the plaintiff appellant did not get any opportunity to plead evidence in respect of the amended issue. Order 14 Rule 5, it was amended, Your Lordship. Can you see, Your Lordship, page
number?
Page number 95. Page number starts from page number 95, issue number 4, Lordship. Bottom portion. Whether the plaintiff purchased the suit land as described in the Schedule C in the plaint with a 10 feet wide entrance path commencing from LNB Road. In memorandum of appeal, it is stated that issue number 4 not properly decided and wrongly appreciated the evidence of the plaintiff appellant. Mr. S.K. Shamsi, learned advocate for appellant, has submitted that issue number 4 was defectively framed as the appellant has not pleaded the road. Considering the pleadings and materials on record, this court is empowered under the provisions of Order 41 Rule 25, read with Order 14 Rule 5 of the CPC, amends issue number 4, and the amended issue number 4 is whether the plaintiff purchased the suit land as described in the Schedule C in the plaint, and there existed a 10 feet wide entrance path commencing from LNB Road. This issue was amended, Your Lordship, by the first appellate court. But in this respect, the first appellate court did not allow the plaintiff appellant to produce any evidence in respect of the amended issue.
What is the major difference between the earlier issue and the amended issue?
Lordship.
Earlier issue was
Earlier issue was, kindly see page 5. Whether the plaintiff purchased the suit land as described in the schedule C in the plaint with a 10 feet wide entrance path commencing from the LNB road. There was no specific pleading on behalf of the plaintiff appellant that he has purchased the suit land including the 10 feet wide path. No such pleading was there. And it was later on amended whether the plaintiff purchased the suit land as described in Schedule C in the plaint, and there existed a 10 feet wide entrance path commencing from LNB road. My plaint, kindly see your lordship, prayer portion, your lordship.
no. How the first appellate court has framed the issue?
Lordship, 96, it is 96 page. Whether the plaintiff purchased the suit land as described in the Schedule C in the plaint, and there existed a 10 feet wide entrance path commencing from LNB road. That was the amended issue framed by the first appellate court.
No, there is no difference.
Lordship, there is difference, a little difference, Lordship.
How?
Lordship, kindly see now page
No,
20.
If the material already placed on record is sufficient to decide the issue,
Lordship,
then why the trial court or no, first appellate court will remand the matter to the trial court? First appellate court is empowered to deal with the issue.
Yes, your lordship.
Then
If there is evidence in respect of the said issues, your lordship.
firstly, there is no marked difference between this issue, earlier issue, and the new issue framed by the learned first appellate court.
Lordship, my suit was for, kindly see, my prayer portion starts page 29.
No, you come to the point.
The schedule, if your lordship look into the schedule, then it will be clear. Schedule and prayer portion. The plaintiff's case is that, lordship.
If paragraph number, no, in page number 96, paragraph
Lordship.
number 21, if issue number 4 is recasted in bold letters here, it is the recasted issue.
Yes.
Then what is the marked difference with the earlier issue?
In earlier issue, my case was that I have purchased a plot of land measuring 1 katha 5 dasa. The learned trial court, and I did not plead that I have in my plaint and in the sale deed that 10 feet wide road was also I purchased. That was not there.
There is no marked difference. How prejudice is caused to you?
Lordship.
With a recasting of the aforesaid issue.
Recasting, lordship, actually I adduced evidence, lordship, in respect of purchase of 1 katha and 5 losas of land. That is the suit land. That is, lordship, Schedule C land. Schedule C land is land measuring 1 katha 5 losa. Page 31, lordship.
Page number?
Page 31.
Page 30.
Page 31, Schedule C, lordship. land measuring 1 kata 5 lisa out of 2 katas 10 lisa as covered by dag number such and such of patta number such and such Nagar Mahal Moja ward number 7. Here Lordship 1 kata 5 lisa Sidil C land and now Lordship page 30 Sidil A land. Land measuring 8.5 litres out of total land measuring 1 kata 5 litres. I prayed for declaration of 1 kata 5 litres of land title and along with 10 feet wide road which was allowed to use me at the time of purchasing that suit land, your lordship.
No, allowing to use the road and purchasing the road are two different.
Yes, your lordship. That issue, defective issue was framed, your lordship. Kindly see page 95 again, your lordship. The issue number 4.
If I purchase that 10 lucas of land.
Yes, your lordship.
You have purchased.
No, lordship. 10 feet land I have not purchased, your lordship.
That
my suit was I have purchased 1 kata and 5 lucas of land.
Then how the court will grant decree to you? In respect of that plot of
yes, your lordship. And I have proved that I have purchased 1.5 lucas of land, and out of 1.5 lucas, 8.5 lucas of land was illegally occupied by the defendant. That is there. That is proved by the plaintiff by adducing evidence. But observing that plaintiff has successful in proving that he has purchased the suit land measuring 1 kata and 5 lusa, but learned appellate court, your lordship, if your lordship now page 103, your lordship, paragraph 37. From the entire discussion, it is made out that plaintiff had purchased 1 kata 5 lusa of land from defendant number 1. Right, exhibit 1. But plaintiff has failed to establish that he was given possession of entire 1 kata 5 lusa of land. The plaintiff has also failed to prove the allegation of encroachment of 8.5 lusas of land, as well as existence of 10 feet entrance path of his land and narrowing down thereof to 6 feet. Although both the courts below found that I have purchased 1.1 kata 5 lusas of land, but alternatively hold that I have failed to prove that I took possession over 1.5 lusas of land.
Yes, Mr. Bora.
Actually, I am the seller of the land. Both are friend, defendant, and plaintiff. And I have sold a land 2000, more than a year, 25 years, now 40 years, Lordship. 1 kata 5 litres. But they was excluding the road. There is no mention any road, Lordship. Now they are encouraging an exhibit only 6 feet road, which was earlier than more than a year. There is no relation with this scheduled landlord. This is the fact. And number one, the substantial question of law is totally absent, Lordship. Only fact is here, Lordship. I have purchased the land somewhere and that there is no question of law.
So, this court sitting in second appeal cannot go into the facts.
My Lordship.
If there is concurrent finding of fact, this court can
Lordship,
appreciate the fact.
Yes, in respect of lordship, 1 kata 5 lusas of land, there is admission in the written statement, your lordship, that I have purchased.
Lordship. I have kata 5 lusa is admitted, but excluding the road. Road is not mentioned there, Lordship. Therefore, trial court below already dismissed the appeal and decreed in favor of me. This is the fact. More than 40 years, Lordship. Land was vacant more than a year. After 2002, there are some rented people are there, maybe somewhere enclosed there. But I have no relation with my boundary. 2004, I have made a boundary, Poka boundary. along with the plaintiff lordship. So why?
So how the 10 feet road becomes 6 feet now?
I have evidence, your lordship, and the PW2. I have proved that fact that at the
No,
time of purchasing,
I have
lordship,
already stated to you that this could cannot be appreciate the fact.
not only fact,
We
lordship,
can
now
admit the
only
only on substantial question of
involvement
law.
of substantial question of law. Lordship, my no, my prayer was not only about 10 feet road, but my prayer was declaration of title of my purchased land, your lordship. One katha 5 lakhs of land, and which was admitted by the defendant, your lordship, in his written statement and as well as in evidence. Page 38, if your lordship kindly see, page 38 of the written statement, paragraph 11, 21, lordship, that this defendant submits here that though there is mention of 1 katha 5 lakhs of land in the sale deed, this defendant has been possessing the land as claimed since last more than 25 years without any interruption, and the plaintiff in last 25 years could never enter into the land and was never allowed in 25 years, and this defendant has acquired his legal rights as per law, and the sale deed now cannot confer any right to the plaintiff to claim the land as the same extinguished long back, your lord.
So Bora, you are for respondent number 2.
1A, 1-2.
1A, 1-2.
1-2. Another is pro forma
Respondent.
My lordship, that sale deed part, your lordship, that suit land, your lordship. Suit land is 1 katha 5 losa, which is admitted, your lordship.
And regarding this convention,
lordship,
order 41, rule 31. So there is a one recent judgment of Supreme Court.
Lordship.
There it is stated that even if the trial first appellate court fails to formulate any point for determination, but if in the judgment deals with all the issues that
Yes.
are the same with the reason,
Yes, your lordship.
then this non-compliance of order 41, rule 31 is not fatal.
In that case, lordship.
Yes.
Yes.
You produce that judgment then. Okay, you will give the citation to you.
Lordship.
You go through it.
Lordship.
Then we will fix it immediately after reopening of the
After vacation, lordship.
Lordship.
Lordship, not only this question of law, substantial, another I have formulated. I'll convince your lordship on the next day, lordship.
Okay. Your good name, please.
A.R. Som, lordship.
Heard Mr. Yersom, learned counsel for the appellant, and also heard Mr. Bora, learned counsel for the respondent number 1A and 1B.
B, lordship.
1B. This the matter of it. For further deliberation. And caveat you take down caveat would be hard. Caveat instance results.
High level like that.
Oblige, your lord.
For orders, item 20.
The administration council, the others have left. The only council is on legs in court number 2, your lordship. Lordship, I'll obtain the instructions, your lordship.
Yes,
regarding as to what has happened.
date will be fixed after vacation.
After vacation.
My lord, my lord.
I'll
Let's
get
agreed by learned advocate of both the parties. Let's the matter on.
1-6.
Lordship.
My lord,
On that day, is sorry, Lord, it's for the respondent number.
Lordship,
secretary.
number, your lordship, 1, 2, and 6 here.
One to shall obtain necessary experts and appraisals for. Okay. Madam, you are for?
Lordship, for the finance department, however, finance department is not a party here. The finance department shall be a party and name be reflected in the policy table.
Finance department,
Finance is not a major party.
not a party, my lord. As per order dated 2/4/2024, my lord, the court was pleased to direct the government to intimate the finance department to take some necessary instructions.
If it is required.
My lord, if your lordship see the order,
Yes, I have
the department should, my lord, place the instruction.
Okay, Madam, you obtain
Yes, yes.
instruction and you also.
Yes.
For the finance department, why the matter is pending here?
Yes, exactly.
You also take the is your good name, please.
R.M. Borwa on behalf of Mr. H. Alia, your lordship.
R.M. Borwa, Learned Counsel, appearing on behalf of
Mr. H. Alia.
A. Soliha, Learned Counsel for the Finance Department. Also, obtain necessary instruction from the Finance Department as to uh, why the matter referred to the Finance Department by letter number. What is the
Document.
white letter dated 27/5/2024. So, Madam, you obtain.
Obliged, my lord.
Item 20 for orders.
May I please your lordship? Lordship, I filed this IL lordship for stay of the proceeding of the title suit 25, which is pending in the court below, that is pending in the Learned Civil Junior Division, Kacha Silchar. In the CRP notice was issued, LCR, scan copy the LCR is called for. Tomorrow is the date fixed for hearing. So I filed this IL lordship because if my proceeding is not stayed, this CRP would become infractuous. Case of the plaintiff is that I am the defendant, filed a suit for a decree of declaration for eviction or defendants for tenanted premises and recovery of possession on the ground of defaulted on payment of.
What says the case is pending?
Argument stage. My evidence was closed. Defendant's evidence was closed. It was on the day fixed. Could not adduce evidence because my elder brother was operated. We attended with him at Bangalore.
How many adjournment was granted to you?
Total 5.
Total
On 5th occasions, it was closed. Lordship, kindly see.
When the next date is fixed?
Tomorrow is the date.
It is fixed for?
Fixed for argument, Lordship. Defendant's evidence was closed. Even so many judgments also, Lordship, in this regard, Lordship is aware of that. This is not a ground for even then 3 or more than occasions taken. Adjournment. Advocate Salem
Heard
Advocate
Mr. Happy Borgoya, learned counsel for the applicant. This application under section 51 of the Code of Civil Procedure is referred by the applicant or saying the proceeding of PS number 25 of 2013 pending in the Court of Learned Civil Junior Division number 4 Kasar Sipsur. Mr. Borgoya, learned counsel for the applicant submits that the applicant has prepared one CRP IO number 462 of 2024 challenging the order dated 6/8/2024. Is it correct?
Yes, 13, along with 13/5/2024, two orders.
Along with the order dated
Initial order
13/5/2024
13/5/2024 and 6/8/2024.
in the said CRP, notice was issued to the parties and a notice was issued to the respondent and there was no stay order was passed. Mr. Borgoya further submits that thereafter the learned trial court has fixed the matter on
18/12, paragraph 10, Lordship.
on when?
On 18/12/2024. Paragraph
18/12/2024
24
for argument.
for argument.
And unless the said proceeding is stayed, the civil revision petition preferred by the applicant would be in praxis, and therefore Mr. Borgoya submits that till disposal of the CRP number so and so, the further proceeding of the title suit number
25/2013.
25 of 2013 maybe state. Where is that order?
That order is Lordship's
Page number?
Page number 34, the first page, first order 13/5/2024, and second
page number
42, Lordship. (47) Lordship find earlier date in the order 11/9/2024 for argument. Last page, Lordship find.
No, this
Tomorrow's
case
date.
is big. Yes, that
Tomorrow
order.
date, Lordship, order is not annexed, but I submit that statement made in paragraph 10, Lordship, page
No,
30.
we will not believe your statement. You produce the order. Then.
Lordship. After tomorrow.
Tomorrow the case is fixed for argument. You produce the order.
In the meantime, that may be stayed, Lordship. I will produce the order.
No.
Tomorrow, if possible, Lordship.
Yes, tomorrow.
Tomorrow.
As right for Mr. Borgoya, learned counsel for the applicant, based on the fiscal method.
Lordship.
So as to enable him to produce the order dated.
Order, last order, Lordship, 19/11/2020.
19/11/2024.
Item 21.
Obliged, Lordship.
There is a delay of 90 days in preparing the appeal.
Heard Mr. RT, learned counsel for the applicant. This application under section 5 of the Limitation Act is preferred for condonation of delay of 85 days in filing connected appeal
85
against the judgment and award dated 11/6/2024 passed by the learned member MSCP Nogao in MSC case number 216 of 2022. Whereas the petition and the documents placed on record and also whereas the impugned judgment and award dated 11/6/2024. Let notice be issued to the respondent returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. Please the matter after 4 weeks.
For hearing 25.
Wait, please, your lordship. Here, my lord, before going to the merit of the case, only one point, my lord. I have filed a petition before your lordship under Rule 27, Order 41 for additional evidence. So, my lord, as per Supreme Court decision, that additional evidence, if your lordship considered, that may be considered. That is the discretion of the honorable court. Now, my lord, what is my additional evidence? What is my evidence, additional evidence, my lord? Actually, original patadar of the land in question is our predecessor in interest. But what happened, my lord, during
No,
the...
this IA is for what purpose?
No, my lord, IA is over, my lord. Now,
IA is
today
over.
RSA. IA is not pending. All IA is disposed of. Oh, that additional evidence.
Oh, this is RSL. Okay. Okay.
IA number 88 of 2024. So, my lord, I filed this IA for producing...
No, that IA has been disposed of.
No, not dispose of, my lord, but order your lordship will be pleased to see 25/1/24.
So, yes, at the time of hearing of
At the
appeal.
time of hearing, that is that which I
So,
have partaken.
is the matter ready for hearing?
My lord, it is ready for hearing because, my lord, service is complete.
Service when?
Service complete much earlier.
When completed?
Justice service, my lord. Service complete, your lordship will turn to order dated 29/3/2023. 29/3/2023. In RS, my lord. And by that order, your lordship was pleased to fix the matter for hearing. And in the meantime, my lord, due to urgency, we filed a early hearing petition also that was allowed. So it is fixed today.
So, time is about to over.
My lord, your lordship may fix in another day, in 2025, my lord. In the, if, in the second week, my lord, February will be late, my lord, because early hearing petition was there. In January, my lord.
Yes.
In January. 7th of January. Oblige, your lordship.
That's agreed by Mr. MSC, learned for the appellant, this is the matter. Whether this RSA was admitted?
Yes, my lord, RSO was admitted much earlier.
When?
Your lordship would be pleased to see order dated 23/3/2022.
Okay.
My lord.
Records have been received.
Received, possibly received, my lord. I'll check. It may be checked, my lord, that whether else
Okay.
received.